2026. I'm Joey Hargis, the Metro Zoning Administrator, and I'll be handling the cases for the Codes Department. And I'll present any maps, photographs, sketches, site plans that are submitted by applicants, and I'll do that on the wall above the chairman's head on the screen in front of you by means of a PowerPoint presentation. I'll go first in each of the cases and explain to the board the relief being requested or the issues in front of the board. And then after I'm done talking, the first persons to the table up here, there's 4 seats, will be the applicant for the case. We've got kind of 2 different types of appeals in front of the board today, so I'm going to cover the traditional cases of variances and special exceptions first. So the applicant will come first, and if there are parties in support of the applicant's filing, they'll come with them, have a seat at the table, give the board your name and address, and then present your testimony to the board. As you're sitting at the table, to your immediate right, where Ms. Davis sits on the end, there is that clock that sits on her mantle there. That is the time provided to you for your case, and the clock will start after you identify yourself and you're making your presentation. It'll stop for any questions that the board has of you, or if I've got something that needs some clarity, we'll pause it for the question and your answer. And then once you're done with the answer and you start back into testimony, we'll start that clock right back up. If you're here for a case and you don't have opposition present, you'll have 5 minutes to present your case to the board. And then if you do have opposition against your case, you'll have 10 minutes to present your case to the board. That time allotted for you is not per speaker, it's for you as a group. So if you've got an applicant and you've got multiple people who want to talk, be sure to divide your time accordingly before you come up. If you hear an opposition and there's several people in opposition to a case, kind of work out before you come up here of who's going to speak and for how long. But so those are cases that involve variances or special exceptions. We have 2 cases on today's agenda known as Item A appeals. These are administrative appeals of a decision that I've made or an interpretation of a code that's been made. The timings, again, are 10 minutes for the applicant. The applicant will go first and explain their request that they've made to the board. The second party to speak will be me, and I'll speak as to why I did what I did and give explanations for that. In that first group with the applicant would be anybody in support of the applicant's appeal. So if the applicant filed an appeal seeking to overturn the zoning administrator's interpretation, if you're in favor of that request, you will come with the applicant and give your testimony with the applicant in this case. Secondly, I'll go and present the Codes Department and my position as to why I've made the interpretation that I have. And then after me will be those parties in support of my position, and they'll get 5 minutes in the board's rules to present their portion. In all the cases today, if you're an applicant, you do get a chance to rebut testimony of the groups that follow you. So the applicants, be sure out of your 10 minutes or 5 minutes, if you're, 5 you wouldn't have opposition here, but in the 10-minute cases, you want to save some of your 10 minutes for rebuttal of the testimony of the folks speaking after you, either against you or, and then the zoning administrator in the Item A cases, I don't get a rebuttal, so I've got my one chance to say what I want to say, and the same is true of those in support of my position. But the applicants do get a chance to rebut. So that's the nuts and bolts of it today. The board is empowered to act on the cases before us as outlined in Section 13.7.207 of the state law, as well as Section 1740.180 of the Metro Code of Laws. Again, as I talked about, when you come up, identify yourself and make your presentation. It should be noted that if you present false or misleading testimony to this board that may have affected this board's decision, any approval by this board can be set aside by the board after a show cause hearing by the board. The board will go through all cases set on our agenda today that are printed, and copies of which of the agenda are on the table to your left. The board will vote and discuss on the cases right here in front of you and make a decision openly right here in this room. Okay, Mr. Chairman, couple preliminary items. The first of which, we do have a case that was tied up on votes last time. That is the first case on page 2 of our agenda, case 2026-007. And the applicant is requested from me to submit a revised plan, which may not need your assistance with. It may comply with the code, but they have asked to, and I'll ask Ms. Carpenter, who made the motion to disapprove, if I remember. Yes. The request, if you would be willing to set aside your motion, table this case, let me look at a revised plan, and then I'll bring it back to the board in 2 weeks and report back to you all. So.
Yes, I'll be willing to withdraw the motion.
Okay. And for our legal counsel, I don't know, do I need that in a form of a motion in a second? Okay. Yes, if you don't mind, we'll get a motion and a second and a vote on that. So if you wouldn't mind, just
okay.
You'd make a motion to
okay, sure. I'll make a motion to withdraw the motion.
I second.
Motion and a second.
Okay. So the motion that was on the table previously for case 007 at 725 Atkinson Lane, that case will be heard here in 2 weeks on the 19th of February. Sorry, it's been the longest January and February of all time. But it'll be here 2 weeks in this room. This is the notice for that, so parties will come back. In the meantime, the applicant's going to submit a new drawing to me. I'll review in those 2 weeks. If it complies with the code, we'll withdraw the case and issue the permits. If it doesn't, they'll still need to seek a variance from this board. So, all right, thank you, council member, and any other parties that are here for case 7. Okay, the next bit of business, the board does allow council members to speak on a case before we get into the public hearing portion of our case. Are there any other elected officials present? I did not see any others present. Okay, Mr. Chairman, so seeing no hands, we'll get into the next phase, which is a consent agenda. So a consent agenda is an agenda, it's a list of cases recommended by the chairman of the board for approval to the remainder of the board seated before them. If in the chairman's opinion that the applicant has met the criteria for the variance or the special exception for which they've requested, and he feels that that testimony would not alter the material facts, A, and B, that there are no parties in opposition present, he recommends the case for consent. When I call these next cases, if you are here in opposition to any of the cases, raise your hand, please. Okay, so our first case recommended for the consent agenda is case 2026-11, Michael and Wendy Warren, the owners of the property at 1808 15th Avenue North, requesting a variance in the street setbacks in R6. Well, have seats, sir, just 1 second. Are there any parties present in opposition to case 11 on 15th North? Mr. Chairman, seeing none. The next case recommended for the consent agenda is case 2026-12, Carl and Mary McWhirter, owners of the property at 101 East Campbell Road, requesting a variance for outdoor storage in the CS Zone District. Are there any parties in opposition to the case on East Campbell Road in Madison? Mr. Chairman, seeing none. The next case recommended for consent is case 2026-13. Mr. Scott Boyle is the appellant of the property at 2614 Old Lebanon Pike, requesting a special exception to allow the use of the former veterinary clinic for a kennel and CS. Is there any parties present in opposition to case 13 on Old, and you're in opposition, ma'am?
I have questions.
Okay. Well, I tell you what, let's do. Let me finish this portion, and we'll come back, because that case is a little bit down the agenda. You're welcome to come over to me, and I'll answer the questions and kind of have a little break here. But yes, ma'am. All right. All right, we'll set aside case 13 for just a moment. The next case recommended for consent is case 2026-14, is the Layson Building Company at 647 Devon Drive, requesting a variance in street setback in RS20 to construct a new house. Is there any parties present in opposition or have questions to case 14 at 647 Devon Drive? All right, seeing none, Mr. Chairman. The next case recommended for the consent agenda is case 2026-15, Donnelly Timmons, the appellant, 912 Tower Place, the location of requesting variance in side setback and maximum allowable size in the RS20 district. Are there any parties present in opposition to case 15 at 912 Tower Place? Okay, Mr. Chairman, let the record reflect, I see no hands. And then finally, the last case recommended for the consent agenda today is case 2026-17, Grand Living Construction, 1025 Meridian Street, requesting a variance in street setbacks to reconstruct a new single-family residence on the property. Are there any parties here in opposition to case 17 at 1025 Meridian Street? Okay, Mr. Chairman, just to recap, your consent is cases 11, 12, 14, 15, and 17.
Okay, is there a motion on those?
Make motion to approve consent agenda.
Okay, is there a second? Second. There's a motion and a second. Any discussion? Okay, all in favor of putting those on the consent? All right, those pass.
What just happened? If you are here for cases 11, 12, 14, 15, and 17, your cases have been approved. You can follow up with the Codes Department beginning on Monday to obtain the zoning approvals for your request. And if there are any other items you need to get taken care of, please do so after that, and we'll get the permit underway. So again, if you're here for cases 11, 12, 14, 15, and 17, you've been approved, and so you're free to go. You're also welcome to stay with us for the next few hours to hang out with the rest of us. Okay. I do have the question from the young lady over on the left side. I'll talk to her at case 14, but the first thing we'll get underway, let's get our first case kicked off, and then I will speak to that person with a question. So let me cue that up. So the first case that'll be before us be a case on the front of the agenda, case 2026-003. Mr. Jason Hallman is the appellant. The Seven Hills Club is the owner of the property at 1317 Hildreth Drive, requesting an item A appeal challenging the zoning administrator's interpretation regarding the club in the RS40 district, referred to the board under section 1740-180A. This was deferred from the meeting of January the 15th. We did not hold a public hearing. It was postponed prior to that agenda. So first, Mr. Hallman, let me pull up the PowerPoint. I'll give just a brief overview of the request, and then I'll turn it over to Mr. Hallman to present his side of the case. Again, Mr. Hallman and folks in support of your case will have 10 minutes. Once I'm done, I'll turn it over to you. And once you get your introductions out of the way, we'll start the clock. And, okay, then first things first. Let me pull up.
You want me to do an introduction now?
Oh, no, that's okay. We'll, just a brief, give him an aerial photo of the subject property involved here. These are the properties at this corner here at Hildreth, and the other name street is blanking out of my mind sitting here. But this is the Seven Hills Club, and the aerial photographs taken approximately 1 year ago today. Good news, board members, in our March meeting, I'll probably have new up-to-date aerials to show you. Mr. Hallman contacted me and asked to, in regards to some conditions that were placed upon the Seven Hills Club, and I'm going to hit sort of high level of this. As to the conditions placed on the club back in 1960 by a Board of Zoning Appeals at that time, and listed in those conditions, it was alleged by Mr. Hallman a couple items that one, that there was a restriction of the number of members permitted here at 500 families is what the case stated, and two, that the board prohibited the consumption and sale of alcohol off the premises. I wrote a letter to Mr. Hallman back dated August 28th of 2025, and to Mr. Doug Sloan, who was the attorney at the time representing the club. And I'll just read into the record. You've got a copy of this, but it says, "Gentlemen, after a thorough review of the files available to me regarding Seven Hills' mandatory procedure, now known as a special exception, I've made the following determinations as to what the board adopted as to the conditions placed upon the use of the property. Seven Hills is allowed to operate under the following conditions, as shown in the attached order from the board. And in quotes, it states, "Therefore, it is the decision of the board that the request of appeal case 60-18 as set out and described above and further described in the case record be and is hereby granted, provided." And it listed out the conditions, the two of which, I won't read those conditions, you've got those before you, but the issues was item number 6. The conditions stated that no alcoholic beverages be allowed on the premises for sale or consumption. And my letter goes on to say, it's my interpretation and position that these are enforceable today with the exception of condition number 6. The sale and consumption of alcoholic beverages is not a zoning regulation that did not then in 1960 nor now falls under the jurisdiction of the Board of Zoning Appeals or me as zoning administrator. The Metro Beer Board has exclusive jurisdiction for the sale and consumption of beer in Davidson County, and the Tennessee Alcohol Beverage Commission has exclusive jurisdiction of the sale and consumption of liquor. Neither the Board of Zoning Appeals nor the one constituted today, neither that Board of Zoning Appeals nor the one constituted today have any jurisdiction over these matters. As such, I shall not enforce the provisions in my duties as zoning administrator as set forth in 1740-010. Implicit in these duties are that I shall not enforce laws that lack subject matter jurisdiction over. I do see discussions in the minutes regarding which had discussions over the anticipated maximum membership of 500 families, but the board chose not to include those restrictions in its order, in its order, meaning those 8 conditions I'll list out. The board chose to enumerate those 8 items listed above. I have located notes which mention somewhat different conditions totaling 12 that appeared to have been discussed, but those are not conditions placed within the final board order. Either of you may disagree with this interpretation and have the right to appeal to the BZA. So that's what's before you today, and that's how they got here. I'll stop that portion of mine as far as the preamble. I'll come up after Mr. Holloman to kind of discuss my thoughts and thinking behind where I come from on those. With that, Mr. Holloman, is that a fair summary, I guess?
No, I think it is. We want to be sure before our time starts, we got a slideshow up.
Yeah, absolutely.
Yeah, okay.
I'll pull it up right now. Let's see.
While you're doing that, I'll just introduce myself. My name is Jason Holloman. I'm here on behalf of the appellant, Mr. Anthony Rohde, and other affected neighbors. And I have here with me Mr. Michael Lewis, who is an attorney, but he is a neighbor in this context, and he's going to be presenting as well.
For the record, can you be sure and give us your address?
Sure. My address is 4210 Park Avenue.
And my address is 1307 Hildreth Drive.
All right, thank you.
All right, Mr. Holloman.
I'm going to turn it over to Mr. Lewis to go through this, but I want to let you know what you're looking at. This is a very old special exception permit, actually predates Metro government. It is what we now call a special exception permit, and we take issue with 2 conditions. One as to membership cap, which is referenced at 500, and the other is as to the consumption of alcohol on the premises. And so I'm going to turn it over to Mr. Lewis and let him explain the details of the permit, and then I'd like to offer some legal analysis.
So we were able to obtain some additional records from the archives that I'll present in the slideshow. If you'll advance to the next slide, please. The permit is divided into 3 parts. We're gonna show it on the next slide. On the top of page 1 is the introduction. Bottom of page 1 and top of page 2 are the findings of approved, planned, and findings of fact. And then the bottom of page 2 running to page 3 are these 8 numbered operating conditions. If you'll advance to the next slide. So in the introduction, you've got some background facts relied upon by the 1960 board to issue this permit. Critically, though, if you look in the orange box, this is issued as an exception to the underlying land use requirements. It makes it very clear this is a special exception to the existing underlying residential zoning. This is not a non-conforming use. Next slide, please. So bottom of page 1, top of page 2, here's the approved plan and findings of fact. If you'll direct your attention again to the orange box on the right side of the screen, it makes it very clear that the decision of the board is set out and described above. In other words, it's described on the top of page 2 and back on the bottom of page 1. And that makes a lot of sense because this is the portion of the order that contains the approved plan for the special exception and also the findings of fact from the 1960 board. Next slide, please. So there are 6 elements in this approved plan. I'm going to talk more about them in a site plan in a couple more slides. The first one is the recreation facilities. The second one is a northern parking lot on Hildreth Drive. Third one is a southern parking lot on what's now Mountain View Drive. The fourth element there is 162 parking spaces between those 2 parking lots. The fifth is the privet hedges, and the sixth is the 500 member cap. Next slide, please. So this permit also contains a finding of fact, just as the current BZA would hold for a special exception. It confirms that the approved plan, approved by the 1960 BZA, complied with then applicable zoning regulations for special exceptions. Next slide, please. This is a site plan that was located in the archives. As you can see on the left side, it contains the appeal case number, and it depicts the 5 physical elements. In the middle, you can see the recreation facilities. On the top, you can see the northern driveway with 75 parking spaces. That's actually a depicted number. Same with the south parking lot, number 3, 88 parking spaces on what's now Mountain View Drive for a total of 162 places. Fifth element's not in dispute. The sixth element is this anticipated maximum membership of 500 families. So it appears that that is a standalone permit condition in this approved plan. It could also be construed as a key assumption relied upon by the 1960 BZA to confirm that the facility would be adequately parked at 162 parking places, given a maximum of 500 member families. If you go to the next slide, you can see, I know it's a bit difficult to see, but if you look at the bottom left of the screen, this is an approved plat with a stamp by the Planning Commission. It depicts this club as having 500 members. So all the way through, the 500 members are carried through in the permit and in the approved plat. Next slide, please. So what's built? Well, you can see the recreation facilities in the northern parking lot are built, but the southern parking lot never gets built, which means that you never get anywhere close to 162 parking places. And the club recently has gone from 500 member families to somewhere in the neighborhood of 650 member families without adding additional parking. If you go to the next slide, here's the result. You have parking all over these residential streets. If you refer to Councilmember Ewing's letter in the file, she notes there is a real safety concern addressed by multiple neighbors. There's no sidewalks. There are no shoulders. There's a blind intersection. These are very narrow, hilly streets, and pedestrians are forced to walk in the middle of the street into oncoming traffic. Okay. So, next slide, please. Sorry. So, and then briefly, these are the 8 numbered permit conditions. Number 6 is what we're here to discuss. I will point out that conditions 1, 4, and 5 address public health requirements outside the zoning administrator's general jurisdiction. Next slide.
So then, really just to lay out what our legal arguments are here, we have 2 disagreements with Mr. Hargis in terms of interpretation. One is that the 500 cap is baked into this permit. As you can see, it references, as was said earlier, that this decision of the board, as set out and described above, and as further described in the case record. So the 500 assumption is part of this permit, and the 500 assumption is tied to the construction of this 162 parking spaces, both of which are reflected in the body of the permit, but also importantly, demonstrated on the site plan as site plan conditions that were both part of the BZA file and separately approved by the Planning Commission. So our disagreement with Mr. Hargis on this front is that, in fact, this is a condition of the permit, even though it is not enumerated as these separate time, place, manners that were added on. Those are not mutually exclusive. You can have the assumptions that were built into the body of the permit, but also have those additional conditions. So that's with regard to the 500 cap and the number of parking spaces that have not been built. So the number of families has been exceeded while the baseline parking has not been built. In terms of the alcohol requirement, Mr. Hargis says, well, there are enumerated conditions, but because alcohol consumption is not regulated as zoning, I can't enforce that condition. We disagree. Specifically, you are allowed under MCL 1716-150J to make reasonable conditions necessary to protect public health, safety, and welfare. Those can be a panoply of things, and you can see by the other conditions, Next slide, sorry. You can see by the other conditions that no trash is allowed to be burned as required by the health department. Well, that's clearly a health condition. That is not part of the zoning code as well, but Mr. Hargis says he can enforce that. The swimming pool has to be in compliance with state and county health department regulations. Again, that's not a zoning regulation, but it is a condition of this permit that can be enforced. In other words, this permit can be revoked. There can be a show cause hearing if, in fact, these conditions aren't met. So no alcoholic beverages on the premises is another community time, place, and manner condition that can be placed on this permit, was placed on this permit, and should be enforced just like the other ones that relate to other departments. So that is our request. I'd like to reserve the balance of our time, but we're asking that the cap of 500 be acknowledged with the required parking that should have been built with it, and that no alcohol be considered an enforceable condition, just like the other conditions that relate to separate departments within the metro government. So I'd like to reserve the balance of my time.
Let me see if you may have some questions. Any questions for the applicants?
Digesting everything.
Okay, well, you've got 2 minutes and 20 seconds left for rebuttal, so thank you. And we'll hear from the opposition.
Yeah, I mean, you're welcome. Come on. Mr. Chairman, members of the board, Joey Hargis, Metro Zoning Administrator. This is a portion I will not need 10 minutes to present my side of the story. And I apologize, I wasn't able to hear all of Mr. Holland's case, but I did hear parts of it. I had to deal with the matter out in the hallway, but just to give you a little bit of start a clock on myself, to my address is 800 2nd Avenue South. All right. To give you a little bit about my thought process behind it, one, obviously this case is very old. We're going 66 years it'll be this year. So in those conditions we look at, those conditions I'll admit are enforceable, that this board placed on them. I chose in the instance that item 6, in my belief, and with, hello? Okay. That in my belief that the board at the time, as I stated in my letter, did not have the authority to place that condition. A, because I believe it is A, not a reasonable restriction, A. B, not a restriction on from a zoning perspective, the use of land in that. I've since, in consultation with the Metro Legal Department, so I'll do it officially now, is alter my position that the board could regulate the sale from the premises as a valid legal restriction. But I guess I come down to the point of reasonable condition on the consumption side. And when I think of reasonable conditions, and I think I've talked to you guys, if not this board, members of this board in prior trainings, that a reasonable condition has to be something tangible and enforceable. So from the standpoint of me, I would read this as the alcohol beverages would be, consumed or sold on the premises coming from the club to the members, that direction. Not a prohibition necessarily from a member wanting to sort of have a tailgate out here and to bring their coolers. As I talked with Mr. Hallman kind of before this meeting, from the enforcement side, obviously we're not standing out there on the property seeing what's going on each and every day. We would need some photographic evidence that, if you agree with Mr. Hallman's position, that they're violating this condition and that I got it wrong.
But Mr. Harris, why? I mean, Metro Parks doesn't allow drinking in a lot of parks, right?
That's true.
And so, I mean, that can be enforced, and that's considered, and that isn't something implemented by the beer board or the.
No, but I think that's the difference for me in a public park. They are tasked with overseeing the operations of that public establishment. Parks operates this, so Parks obviously sets their rules for the operation of the public's park versus private property. In that, and just in my mind, that as Mr. Holland talked about, the burning of leaves on the property is pretty evident. That's You could go by there and see that that's occurring. You could tell that these types of conditions are easily enumerated. Do they have enough? Are the lights off at 10 p.m.? Have they stopped doing it? Are they operating on Sundays and holidays? Those are types of things that are easily enforceable. I'll admit that surely the board took into consideration the number of members in granting this request. That would have had to have been a discussion. It wouldn't be reasonable to talk about, hey, here's the club we're wanting to operate and how many folks we're doing, and not take that into consideration. Just for the point of me, that conversation is more dicta above the actual order. I mean, the board should have incorporated you're limited to X number of people to something like that. It's clearly in the discussions. Don't doubt that at all. And really the review today is not granting Seven Hills the permission to do something that's not enumerated. It's just, did I get it wrong? And I'm totally comfortable if I got it wrong, If this board rules that way, then I'll go enforce. And likewise to Seven Hills and the gentleman representing Seven Hills coming behind me, they can come back to this board and seek to have these conditions removed or put new conditions.
And wouldn't that put us in a process where if they could come back and ask for if we find those conditions are enforceable, they could come back and ask for it to be modified, and we would go through a process in which we would reconsider those things?
Certainly, yeah, it would be a special exception request. It would not be a request in front of the board, yes or no, the club can operate. That's settled. The club's here. So the request coming back before you would be modifying the conditions last placed by a prior board upon its operation. Obviously both parties here today have the right to appeal to this board's decision to Chancery Court. But I at least tell you from my standpoint, that would not be a choice that Metro would make. We're looking for guidance. Either I got it right or I didn't. That's fine. Whichever path that settles out today will lead to the enforcement side of, here's what I'm coming to Seven Hills saying, okay, show me how you comply with these things. I think it's also important too, with that, the burden of proof a little bit is on Mr. Hallman's client, is that they are truly violating the enumerated conditions out. I mean, we've talked about it around the edges of things with parking and such. But,
It's not a question of violation, it's a question of are they effective or not, really? Isn't that what they're not.
Well, yeah, I mean.
You're finding that they're just not effective.
Mine.
That's their beef, I
yeah,
think.
Yes. They're,
whether they're violating or not, your position is it doesn't matter because they're not effective, right?
well, I'm not saying all the conditions are effective. I'm only pointing out that
The
item
two
6.
we're talking
Yeah.
about, yeah.
Item 6 to me, the number of people's not listed in the order. My take on it is, hey, they didn't put if the board felt there was a cap, they should have put it in their enumerated enforceable, here's what we're restricting you to. They clearly talked about it. There's no question. They talked about, there could be as many as 500 families out here. Again, what's a family? 1960 family might be a little larger than a 2026 family, right? So it helps for clarity, made this a lesson for all the board members, clarity in your order. What do you want exactly so we know what you're talking about? But anyway, sort of the long and short of, I looked at the conditions from 1960, reviewed the records that Mr. Holman submitted from the archives. We've got those and looked at those. We have some records that are shorthand. I don't know of a person alive that can read that, at least in my office. So don't know what may lie in that. But this is the sort of order produced by the board at that time, were those conditions that Mr. Holman showed. So with that, I will.
One quick question, Joey.
Certainly.
Going back to item number 6, you said at the beginning, you said you believe the board at that time didn't have the authority to put that condition on there?
I do. To me, that condition, although might affect the operations of the business, in my mind, that is not a land use restriction. This is not a bar. This is not, it would be akin to you coming for a special exception for a church and saying, hey, you can't do scrap operations and you can't, you're talking about things that don't get to the aspect of what's in front of you. You know, it would be, in my mind, you're saying, hey, we're granting the variance for your street setback, but you can't be but one-story house. I mean, can you put that restriction? Yes, but should you? No, it doesn't make sense. There's no real nexus between what you're saying they can't do and the operations of going on. Now, to the number of people, there could be some connection between. Clearly, there was a discussion about how many members and how big is this operation going on out here.
But it is a condition of it. You're in a disagreement that it should have never been, but it is.
Yes. Oh, I don't, yeah, I'm not saying the condition doesn't exist. It clearly does. I just
And you
don't,
said
I
that
didn't
legal
feel that.
counsel said disagreed, right? You
What's that?
consulted with Metro legal counsel and they disagreed.
They disagree with me in the sense, and obviously they're my lawyers, so I'm gonna listen to them. Disagree with me with my aspects that the board could not regulate the sale of alcohol from the board from the club to its members.
Okay.
They believe you can. I don't know, they were less
Can or can't, sorry.
can restrict the sale from Seven Hills to its membership. Less guidance on whether somebody can just roll a cooler over there and have a few adult beverages after swimming or playing tennis. You know, again,
Mr. Artis, why should we assume that in 1960, right or wrong, the board then considered that the preventing the sale or consumption of alcohol was necessary to protect the public health, safety, and welfare, whether that's true or not? You can agree or disagree with that, but I mean, what evidence is there that they didn't believe that that was a condition they put on there what you're saying is it doesn't relate to land use, but the standard seems to be we can put any condition on that we think is necessary to protect the public health, safety, and welfare. And
I mean, it's a
seems
swim
to me
club
like
with
that's
kids.
what they thought in 1960. Again, whether we agree or disagree with it, and I think if the club were to file an application to modify the special conditions, they might get different results from the current board. But going back to 1960.
That could have been considered by the board at that time to be a reasonable condition to protect the surrounding property owners.
Well, and also that it seems like it's a family, kids, and, we're just trying to go back in time here a little bit, but I see where you're going.
And Joey, I have a question.
Certainly.
Because I don't know if it's before us, because everybody spent a lot of time on condition 6. But you guys went back in the archives for a reason, pulled up that order. Does it matter today that, because they showed the pictures of where they were supposed to put a parking lot, but there isn't one. And I do know for special exceptions, we typically do look at things like parking and impact. That's something that we do reasonably look at. Does that impact our analysis today, or we just merely look at the two conditions that are at issue?
I don't think it should be a concern of this board. It would need to be my concern if you're feeling that, based upon Mr. Holland's testimony, that the site plan this is the plan the board adopted, then.
That was my question, because normally, I know in the past you've told us, you've advised us wisely, that, if we put conditions in place and then someone comes up a year later with a show cause order with proof that they're not complying, then we would have a hearing and we would review that. I don't know if they presented the proof. I don't know if that's something that.
Right. Well, that's more, I guess, from the after this, the enforcement side of.
That's, that you already answered.
Yeah, I've got to
Okay,
make a
thank you.
determination of, okay, what's the approved site plan? Those are really things we didn't get into in depth. They've raised it today, and certainly, the outcome of this is going to affect, okay, the board's agreed with Mr. Holloman. I need to go back and look at the approved plan and see what Seven Hills is doing and, compare those items. I mean, those are things that will spawn from today's result, but.
Okay, thank you. You answered my
no problem.
question.
All have no more questions for me. I'll reset for Mr. LaFever.
I got one last question.
Okay.
Sorry.
You're fine.
This goes back onto the conditions. Right above it says, as set out and described above and further described in the case record below. I don't know, about the 500-member cap, I feel like it's saying both, you know, I don't,
The only thing I would say to you, the text, Mr. Hallman had it up there, I'll show it again. They said families. I mean,
yeah, and it didn't define
don't know what
families.
that means.
I understand that. I understand that.
my wife's family, it could be like 3,000 people, you know. If it's my family, it's probably about 1,000, you know.
Well, but they've determined there's 650 families, so I mean, somebody's figured, I would assume they register by family. I mean,
Yeah, like one family member is a member, and then, you
Right,
know,
yeah, I don't think
it's usually the way it works, right?
I would think so, yeah.
Yeah.
Yeah, there's, I don't know if you can see my cursor, there's discussion here. There it is, he's actually underlined it here, be 500 families.
So, Mr. Hargis, wouldn't we, if we agreed with you, that would necessarily mean, wouldn't it, that there was no cap on the membership at the club? They could have 2,000 families as members.
I think that would, I mean, I did make a finding that, hey, they didn't really place a condition in there that said it's X number of people. Yeah, I mean, that's something this board would need to find one way or the other, that I erred, and hey, we really do think it is.
But if we agreed with you, the necessary corollary of that would be that there was no cap on their membership.
Correct, because it would not have been in the area listed after the words, therefore, this board is the decision of the board.
Yeah, I got you.
But they talked about it. They clearly talked about it. I can't deny that it was discussed, but I guess I'd look at the words on the page. If it was really super important, they would have enumerated it as a condition. Maybe they didn't perceive it would ever have 500 families, you know, maybe.
Or it could,
And the as described above, and the fact that it says that it is anticipated that the maximum membership, I'm not arguing with you, I'm
Yeah.
just asking, I know that this is an interpretation thing, but to Mr. Ransom's point, I don't know, like, it seems like that was not just, forget the discussion, it's in the approved plan, so I do have something in writing to like go back to and look at,
Yeah, it says 500 families on there.
but again, I don't know.
Yeah.
I appreciate it.
No, if the outcome of this is you believe, yes, there's a restriction, great. There's another guideline for me to work with, you know, another parameter to deal with.
If this was in front of us now, what's the board, do we use the word members? Do we
Yeah,
use the word,
If you started a motion like this today and you didn't talk, I mean, let's say you spent 20 minutes talking about how many people are out here in this club going, and then we get to a motion, and you're not telling me you want to restrict the number, me or your lawyer should be stopping you and saying, hey, whoa, y'all spent 20 minutes talking about numbers. Clearly, that's important. Do you wish to put some kind of cap for us so we know? You know,
yeah, but couldn't that have just, I mean, that could have been an oversight.
Could have been.
Drafting oversight.
Well, again,
It's pretty clear that they were focused on the 500 families, not only in the written resolution, but in the planning of this thing, requiring the parking spaces and putting it on the plat. Anyway,
yeah, I can't, there can be, admittedly, I can make suppositions reaching into the past before my, you know, the same way that looking at it a lens from today's point of view, looking back then may seem, that makes no sense. You know, what does that mean? Same way, you know, going forward. At the time, they may not have envisioned to give it some fencing. You know, maybe in their mind, it wouldn't have existed 66 years later. I don't know, you know, but that's, I guess, the overall story, I guess I'd say, of all cases in front of you, if you want some conditions on it, be specific. They run forever, you know, project
They
change
run
thing.
forever unless
Yeah.
the club makes an application to modify it, and then we would go through a process.
Or record it, yeah.
We could require, you know, theoretically, traffic studies or whatever else we needed to do.
Correct. I said to someone, not, you know, I have seen restrictions on deeds and on things in front of this board where they restricted, where African-American families not allowed. I mean, that's, from my point of view, is just ludicrous, but, you know, from a 1950s era, it might have seemed reasonable to that board then. I'm not, obviously, a judge invalidated that, and with the adoption of the Civil Rights Act, that goes away. So your orders can evolve over time as the law changes, but anyway. As I said, just kind of last 5 seconds wrapping up. The case before you is today, did I get it right or didn't I? Whichever way it goes, will act accordingly. I don't want to take away from Mr. LaFigure's got an argument he wants to make, so, and I've got a PowerPoint I'll pull up for him. But, okay, this portion, Mr. LaFigure, if you'll identify yourself, I will get your PowerPoint up in front of the board.
Yes, Adam LaFever, 1702 Sweetbriar on behalf of Seven Hills.
Thank you for distinguishing your PowerPoint on the title screen, because I was about to open Mr. Holloman's again. Okay, sir.
Okay, so what we saw from Mr. Holloman's presentation was the 1960. This was amended in 1961. Next slide, please. Went before the Board of Zoning Appeals approximately a year later for construction of certain additions. When the original was passed, we were just in the county. When this application occurred, we were county and city. So they effectively had to reapply for this. Next slide, please, Joey. That's the reapplication. You'll see appeal one to the city on top. The other one says the county. So that was the reapplication for the club for additions to what was previously approved. Next. This is the site plan that was approved in that amendment. That is primarily the way it appears today. Next, Joey. You'll see 538 feet is the frontage. It's identical to the site plan that was approved. Next, Joey. Regarding parking, the club has an agreement with St. Bartholomew's Church, which is approximately 2 blocks over, where they get an additional 85 parking spaces if they need it. That was utilized last year. Next. And throughout Seven Hills history, it's consistently applied to this board for different items. Like this one, the board granted the additional tennis courts to be constructed. Next. This is another one from 1977 where the board granted lights over the additional tennis courts. Now, important, the reapplication to the city did not contain the alcohol restriction. It was not there once they had to apply before the municipality of Davidson County and Nashville. Now, when looking at the language, I think we have to look at the way the board operates. It operates with parliamentary procedure. In the 1960s, it was primarily Robert's rules that were followed. Under Robert's rules, resolutions have 2 distinct parts. The first one is the preamble, which we argue is the portion, the factual discussion. And the second is the actual operative action that's taken. That is what is installed in those enumerated provisions. The recitals in this case could be struck entirely and the conditional uses would still remain, items 1 through 8. Next. This is directly from Robert's rules. The preamble should never contain a period, but each paragraph should close with a comma or semicolon. You'll notice that the preamble in this one, all commas and semicolons, not a single period. Next one. Now, how this applies to the 1960 conditional use. You have findings versus conditions. The first part are the findings. The board finds that there are approximately 500 members, and there are a lot of anticipated and approximately. Those aren't conditions. That's through the preamble. And there's a chart of be it resolved. What does that mean? It's the preamble, it's the recitals, it's the finding, the background, it's what was considered. That's where you have, again, the terminology anticipated, proposed, will accommodate. None of that is finite or definite. Then you have the second half, therefore it is the decision granted. Those are the operative provisions, the binding decisions and conditions. It's called a conditional use because it has conditions for it to be used, and those are items 1 through 8. These are those items again. First one's not disputed. Second one, there was a hedge evidently that was supposed to be installed. The only ones of these that are contested are the alcoholic provisions. The club does not sell alcohol. It does not monitor and do cooler checks of people that walk through the door. It doesn't have a security guard sitting at this family establishment making sure nobody's bringing a beer in. Now, Joey, if you'll go back to the second map from 1961. Keep going. Okay, so this one, you'll see back to the parking, you'll see the parking spaces up front. This is physically impossible. Planning did not communicate evidently with zoning when they approved this because you cannot physically fit that number of parking spots there. That is where the parking lot is today, those two spaces, and it doesn't come anywhere near to 163 parking spots. However, there's an application that's been made and we're waiting on a permit from Stormwater to build a parking lot to the right of the tennis courts on that picture. As the board knows, stormwater can be a challenge, so we're navigating through the process with that in order to get approval for that. So that new parking lot, coupled with the overflow parking lot that Seven Hills has, with the existing parking spots, will be ample as required, arguably. You'll also notice that this depiction where you see the 100 parking spaces, that actually fits about 30. And so planning just didn't communicate with zoning when they were approving this.
Questions?
What was the reason for the reapplication? Just because they had to go with the city and the county at the time when things were being consolidated?
City and county, and it had to do with building permits. And so when the application was made in 1960, construction had not started. This whole area was under construction by Hari and Smith. They owned everything, including Seven Hills. And so as 1960, they hadn't constructed anything. When they went to apply for the building permits, they were denied, and the city said, no, you have to go get a rezone. And so they had to go back before the board to do the same thing that they'd done a year before the county. And the order from the city, again, like I said, for the revised one, it doesn't have conditions about alcohol.
You're talking about the document we're looking at right now.
There's an order that goes with this one. It's very hard to read, so when I try to blow it up, but there are no conditions on it, like alcohol.
So you're
Right,
saying
but I
the
mean,
city supersedes?
I'm saying the later supersedes the latter, because the county board no longer existed at this point. You have, once you had the consolidation between city and county, you didn't have two separate boards. You didn't have a county board anymore and a city board. You had the metro board, which is what we of course have now.
Is there any way can you pull that, are the other conditions that were in the original 1960, are they repeated in the amendment you're talking about?
No,
Okay.
there are no additional conditions.
So then when this amendment took place, is it your position just all the conditions just went away?
Yes.
So the conditions with respect to lighting, the club doesn't have to follow. Conditions with respect to the hours of operation, the club doesn't have to follow.
Well, it does. I think I would argue that the city supersedes. If the city saw it important to include additional restrictions in the reapplication, I think they would have at that point.
Okay. Questions?
I just haven't seen that other one. It'd be nice to see the hard-to-read reapplication, because it's not, I haven't, go back one, Joey, if you don't mind. Thank you.
Joe, if we want to reserve, I can pull that up so the board can see it.
Well, does it say that it rescinds the prior
It doesn't.
resolution, or?
It's a completely new application. It goes through.
Isn't it reasonable to assume that it was just meant to amend it for further uses, and it wasn't meant to rescind what happened in 1960?
It didn't add any further uses. All it did was change the site plan effectively.
Okay.
The site plan in 1960, I don't know if you're familiar with the location, but it's almost logistically impossible to do because of the hill, Seven Hills, to do what was planned in that 1960. So I think they had to revise it to accommodate for the geography, really.
Okay. But is it fair to say they could have thought they needed to revise the site plan, but they didn't intend to undo what had happened in 1960 with respect to these other 8 enumerated conditions?
Don't know. I'll pull up the order, Joe, if we can punt to the end so the board can just see that order. Again, it's very hard to read, but you can make you can make out, but I'll pull that up and send it to Joey, so we, at the end, if I can reserve time, you can at least see that.
Okay.
Joey, is that okay? Okay.
So one last question, Mr. LaFever. Does the club have a problem? I mean, the club could file a request to have these conditions modified that were put on there before. They were put on there in 1960, 65 years ago. Why wouldn't the club want to do that? And that, wouldn't that help us go through a process where we could look at this without invalidating what was done in 1960?
Club could easily apply. The club's been operating since 1960 under the same parameters. I think a lot of it would depend on what's the result during the application process. Do they have to hire a bouncer to stand at the door and make sure no coolers are going through or nobody has a beer?
Well, but I guess my point is, if the club reapplied and a new board decided that maybe the sale of alcohol wouldn't be permitted by the club, but people could bring alcohol, that might solve that problem.
It could, arguably.
And then with the same thing with the membership issue, if we disagree with Mr. Hargis, that wouldn't it allow us to look at, what the membership was, what the parking was, and look at things in more detail? And would the club be opposed to that?
I think it would depend on the process between that. I mean, would you effectively have to tell 100 families you're no longer allowed to come? Your kids are no longer allowed to swim because we're going through this process and possibly appeals?
I don't think anybody's suggesting that.
No,
I don't
that's
think
not.
there's.
I mean, that's the rabbit hole that I'm talking about, is would the board impose that and say, you have to tell these families they can't come until this is resolved? I mean, we could easily, of course, apply to have them altered, but what is the effect during that application process?
I mean, we could put a condition in that says that. I think, like, to the chairman, like, I think, like, let's not let a good proposal, like something small like that, be the enemy to a good proposal.
Right.
Like, we obviously wouldn't say those families couldn't come. We would probably ask, cap it where it is right now until we go through this process.
I don't think the club would have an objection to capping it what it is right now at 650. I do not think, I would have to confer with my client, but I do not believe there would be an objection to that.
Okay. We appreciate it. Any further questions?
You did say you're going to try to dig that up?
I am, if with Mr. Hargis's position, while you debate the other cases, I can have that emailed over, just so you can see it.
Thank you.
Thank
Or
you
actually,
very
I
much.
might run to my office and email it over during the next 2 hours. And Joey, can I send that directly to your email?
Yes.
No, I think we need it now. I think we need it now, not 2 hours, right?
Yeah, I don't know. I mean, I'm not, unless it says specifically that it overrides the 1960 resolution, I guess if it says something like that, then that might be relevant, but I don't think it does. I don't think, I mean, does it have any language in it, the amendment, saying it overrides or nullifies the conditions of the 1960 resolution?
I'll review, it's very hard to read. I actually got the copy from archives from Joey when we were here on Seven Hills a couple of years ago. You can read the first portion, but as it gets towards the end, the order, so to speak, it really trails off as far as what you can see.
I would just kind of assume that if it had something that was legible in it that said it nullified the conditions, that would have been something that would have jumped out to you.
I have not seen that. No.
Okay, all right. Appreciate it. Thank you.
All right, Mr. Solomon. The time remaining on your, from your first testimony, 221, and do you need your PowerPoint back up?
I don't, actually. No, thanks. Members of the board, I I will say, on the 1961, I agree with the chair. I think unless it expressly rescinds it, I do want to be clear, this would not be the time of consolidation. Consolidation occurred in 1963, so this wouldn't have been a reapplication because of consolidation. I can't speak to what the reason was that they came back, but, you know, additional submittal, unless there is express words of rescission, would not do that. I will point out that I do have the 1977 application that was discussed, and what I will note is that it's a use and occupancy permit request for the property, and they identify the use as private recreation club of approximately 350 members. So it's actually less than the 500, but I really want to use the remainder of my time to say, I think the chair was going in the direction. We are not here to be obstinate. We believe that this is a complete permit. I think it was noted as above and below. And the entirety of the permit works under the assumption that there will be a maximum membership of said club with 500 families. And then there is parking accommodated to address that. I think as Mr. Hargis admits, when we do these, we set parameters because we know this is in a neighborhood. And we set parameters that make this hospitable to a recreational use that is within the neighborhood. In terms of the alcohol compliance, just like you said, we do that all the time. You can prohibit alcohol. We prohibit alcohol at every school that there is here in Metro. We prohibit it in parks. You can prohibit the consumption. Now, if we want to talk about enforceability, that's a separate issue. That's a separate process. That's show cause. But what I want to leave you with is MCL 1740-180C, I think is where the board was going, and we agree. It gives you permission to reconsider a previously approved exception use at any time. And we would be amenable to that. You know, we understand that things evolve, but what we want is clarity, particularly as to the parking, so that there aren't cars all over the neighborhood. And there is a process that this board can go through to address that. The question here today is, are those conditions of an existing permit? The 1960 permit was identified by Chancery Court recently as a complete permit. We believe those are enforceable conditions. That's before the board today. And then if the board wants to consider amendment,
You're out of time.
we're for that. Thank you.
Before you sit down, you may have some questions. No, you don't. Okay, so.
Okay.
Did we have any council person here to speak? I don't think we did.
Do not, Mr. Chairman.
Okay. So we will close the public hearing and discuss.
Who's going first? I mean,
I was going to say that maybe based off of the representations of council for Seven Hills, in light of the fact that they're going through the stormwater process for an additional parking lot, maybe it's not necessarily appropriate at this time for us to deal with that because it looks like they're already going through a process to address that. So I think whatever we discuss, it seems like they're already addressing the parking issue, and maybe, I know that stormwater is a process and we typically stay out of that. So I don't know if there's anything for us to weigh in on that piece today, because it seems like maybe that's being addressed.
I don't know, did they say how many more parking spaces?
He just said a parking lot. We could ask council though. We could ask him.
Yeah, can we ask, like, get some clarification? Can we open that back up for a quick,
What's that?
ask how many parking spaces?
Oh,
that-
sure, yeah, how many? No objection from anybody to reopening to ask how many parking places? Mr. LaFever, how many parking places total?
25 to 40, depending on the stormwater approved.
That you're adding or that you?
And how many do you have now?
105.
So you'll have 105 plus 25 to 40?
25 to 40, depending.
Okay, all right, thank you.
And he also said that they have that arrangement with the church. Maybe people aren't using that
For
arrangement.
85 places?
Yeah.
Yeah, from the photos, it didn't look like they're using it.
So, I very respectfully disagree with Mr. Hargis, because I think that, there was an intent, and I think it's maybe not the best draft of resolution, but I think clearly there was an intent that there was an expectation it would not exceed 500 families. And if we adopt the other interpretation, that means in 1960, they approved this believing that they could have as many people, but they're putting this in the middle of a residential neighborhood. I think they did care about the membership, and I just don't think that they intended to not limit the membership and to have it be unlimited. So with respect to the consumption of alcohol, that was their decision in 1960. Would I agree with it today? No. I mean, I might disagree with I'd have to think about, the club selling alcohol. I don't know, and that would probably be regulated by the beer board and anyway, but that's what they did. And there's a process to amend these. I mean, for me, the question is, what are the restrictions? And whether I agree with them or not, if those are the restrictions, those are the restrictions. They have the right to come back and ask for those to be amended or changed. And I believe today we have the ability to put if we think it's good for a neighborhood that we allow something in the neighborhood, but there not be any alcohol there, then agree or disagree with it. I think we have that authority. I mean, it's not us issuing a beer license to somebody, or trying to regulate it. We're just saying it's something you can't do. So I think that those conditions are enforceable. I will say there's a process we can go through that I would feel like would give me more complete information about. I mean, we've heard a little bit about the parking today, but it would give me, speaking for myself, I feel like more complete information about what is an appropriate limit. I mean, should we limit it to 500 families or 650 families? And if we do that, it gives us the ability to require as a condition that, for example, you have a contract with the church that we know, we are sure about what you're providing in terms of parking. I don't know if we need to revisit hours of operation, but
I think you just hit the nail on the head. Because I was thinking the same thing you were thinking, and I completely agree with you. And I think Mr. Hargis is very wise. I don't agree with him, but it's respectfully. We're the only thing before us is this item A. That's what we have to look at. So we have to vote on whether or not we agree or disagree. And then all that other stuff, that's more appropriate in a separate hearing where everybody gets to come back and say, this is what we're doing. Because we've only heard pieces of it. This isn't a show cause hearing. This isn't, they're not following their order. If that was what we were here today for, then yeah, some of the stuff they presented, we would listen to it, right? But that's not what this hearing is. This hearing is strictly about, do we agree with Mr. Hargis's interpretation? I think we decide that, and if the parties want to come back and duke out all that other stuff, then we hear it then, but this hearing isn't appropriate for that, because that's not what's before us.
I mean, agreement of Chairman and Ms. Davis. And I think, so I was reading the scanned document. It basically says, therefore, it is the decision of this board that the request of appeal case number 60-148, as set out and described above and further described in case record. So I think it means condition discussed above and then listed additional 8 conditions. So unfortunately, it is not listed 8 conditions, but described above. So just focus on 8 conditions of our wise code administrator is somewhat errored, in my opinion. So I think we have to include all described above condition, including membership and everything. And then, in addition, they add soil, fence, fetch, operation of hours, and so forth. So I think it's entire condition. So for that reason, I think I just listed up only 8 condition was by mistake, by error. That's my conclusion.
I would agree, and also, I think we mentioned it earlier, it says 500-member club on the plans as well. So it's not like it's just mentioned in one area. I think the board at the time had a pretty good understanding that it was gonna be, this one says 500-member club, the other one says 500 families, but it's kind of the head of the household is a member, whether it's one person or 6, because you have a whole bunch of kids. That's, doesn't really necessarily count, but.
Okay, well, I'll make a motion then that the administrator erred on this item A matter.
I'll second.
Okay, there's a motion, a second. Any further discussion? Being none, all in favor, all opposed. Okay, so that passes 5-0.
All right, Mr. Chairman, we had just one thing. We had the case on consent agenda previously that we pulled, case number 13. The parties, while this case was going on, went out and discussed kind of concerns, and the folks that were here in opposition are no longer opposed, and they wanted me to pass that along to you. So I'd ask, Mr. Chairman, if you'll put case 13 back on consent.
Okay, do we need to make a motion for that?
Yes, sir, if you
Okay,
don't mind.
So is there a motion that we put case 13 back on consent?
So moved.
Okay, second. Is there a second? Oh, it was second. Okay, so all in favor? Okay, so 13 goes on consent.
Okay, if you're here for case 13, Mr. Boyle, you're free to go. Your case has been approved. Thanks, sir. All right, Mr. Chairman, are you ready for the next case? Okay, Mr. Chairman, our next case is case 2026-009. Jacob Van Heuser, the appellant, Boyle Investment Group LLC, owner of the property at 214 Riverside Drive, requesting a variance in the maximum allowable height and the maximum allowable building footprint in the R10 district. The appellant is seeking to build a new single-family residence, referred to the board under section 1736-470, which is the contextual overlay section. The applicant alleged jurisdiction under section 1740-180-B. Is the applicant present? All right, is there opposition present to case 9 on Riverside Drive? Okay, Mr. Chairman, seeing no hands, sir, if you'll come forward, I'll put 5 minutes on the clock. Let me go through the case for the members and explain why you're asking for a request and why we denied the permit. So, okay, members, again, this property is located at 214 Riverside Drive. 214 Riverside Drive is at the dead end of Riverside Drive in East Nashville, Englewood. Well, it starts in Englewood and ends in East, Englewood. Starts in Englewood, ends in East Nashville. But this dead ends into the park, Shelby Park down there at the very end. This is the site plan submitted by the applicant in his building permit request. The request for the setbacks are fine, no issues there. The issue before the board are twofold. One, the allowable footprint of the residence, which you see here is shown on his plans at 3,475 square feet.
How much is allowed? That's what I could.
Yeah, what's allowed is 2,445 feet, and that is the average of these two residences to the north, and then multiplied. So we look at those, they average out at 1,630. You multiply it times 1.5, which the code allows for, and that provides a maximum coverage of 2,445 and 3/4 square foot. So the variance is approximately 1,000 square foot footprint difference. And then secondly, the contextual overlay allows for, based upon the height of these two structures to the north, allows him to build at a maximum of 27 feet in height in a story and a half. So you got to build a story and a half, and it can't be taller than 27 feet. It can be a single story at 27 feet, but it can't be 2 stories at 27 feet. And his request in his building permit application is to be 30 feet to the height of the structure. This is at the view, I went out yesterday and shot pictures for the board, if you've noticed the dates are, wow, those are recent. Yours truly was without power for 8 days, so I had some catch up to do yesterday. So anyway, this is at the end of Riverside Drive. You see the railroad trestle that goes over Shelby Park down into Hermitage or Donaldson. And then a view of the homes. These are the two homes that were taken for the average in the bottom right-hand photograph. And then a view of kind of an aerial photo showed the prior home that used to be on the residence, on the property, and the former garage that was there. And this is where he wishes to build the new house. So we take the average of these two homes on footprints. And for footprints, we would not count these outbuildings, but we would count this covered patio at the back of this home. So this would count toward his maximal allowable coverage, and it appears that the surveyor did pick that up. So good. That's sometimes surveyors miss the attached carports and attached front porches. So it's like Mr. Hood got picked that up. So it's just these two homes is the average that sets what this one can do in a contextual overlay. But that's it. That's what we've got. No opposition present. Final call. Seeing none. Sir, you got 5 minutes to present your case to the board.
Good afternoon. Yeah, so we're trying to.
Sir, if you can state your name and your address for the record, please.
Sorry. My name is Jacob Van Hooser. I currently live at 902A Douglas Avenue in East Nashville. But I'm the property owner at 214 Riverside Drive, where my wife and our kids are trying to build a single-family house for ourselves. The hardship waiver we're trying to get for this variance is because typically the code reads that you would take the average of 4 houses, the 2 on either side. Because we're at the end of the street, we're only able to take the average of 2, and the 2 just north of us are substantially smaller than the houses in that area. You know, across the street, there's a almost 3,200 square foot house would be to the right on the right side. Even the duplex, yeah, that house that he's pointing to. So all of these houses are roughly, I mean, that's about the size of the house we're looking to build. The house, I think ours is 3,275, and that's 3,187.
You're talking about the houses to the right there.
Yeah, but those ones aren't calculated in the calculation. Right. We just have these 2 small ranches, and they're the same with the height requirement. Those are the 2 shortest houses on the block, compared to the 1.5 story across and multiple other 2-story houses in the same, street and neighborhood. But yeah, that's really all I have.
So your hardship is you believe that
if we were to use the 4 closest houses, the average would allow us to build what we would be looking to build.
the 4 closest, you mean the 2?
The 2 across the street, or
Okay.
just in that corner, is what we were.
Which is not permitted by the code.
Yeah.
Right. You're stuck with the 2 that are.
We're stuck with the 2 that are, because it says, the code is 2 on either side, and because we abut the park, we don't have the 2 on that side.
Right.
Do you know the building footprint of the existing home and the existing garage?
The existing home that was demoed, I don't know the existing footprint. I mean, the garage wouldn't have calculated into that because it was a separate structure. But it was slightly larger than the house next door. I mean, I could find it, but it was still relatively small. I think it was about a 1,400 square foot single-story house.
I was just thinking that there had been previously 2 structures on the site that might be closer in footprint, square footage than what.
Yeah, if you were able to take the garage, because it was a very large shop that was previously
very
there.
big.
Yeah, it was multiple car with another section, so it was rather large back, but like I said, that still doesn't count towards the way that they calculate the
No,
coverage.
I understand,
Yeah.
but I was actually trying to help you.
Oh, I know. I was hopeful that would, yeah,
Yeah. Okay.
thank you.
Okay, any more questions for the applicant? Okay, thank you, sir. We're gonna, adjourn.
Thank you all.
Stop the public hearing and discuss. So I think what the applicant's saying is the hardship, the unique situation here is the property to the right, I don't know whether it's south or what, but the property to the right is not subdivided. So he doesn't get the benefit of,
He
if there
backs up
were-
into the park, so he doesn't get the benefit.
right,
But I was wondering what the other two houses were, just an idea, like, but it's obvious that they're larger from the picture, but that would help me better. You know, sometimes we try to, if we're gonna get a variance like this, we normally try to craft it within, I don't, to be fair, I don't necessarily have a problem with the maximum. For that reason, the height one, though, I think the height is always set by code and not necessarily the other properties, but I was gonna ask Joey that.
yeah, I would like to know that too.
Yeah.
Is the
No
30
problem, I can get you that information.
It's because it's in the contextual overlay district.
Okay.
It's a special
Yeah.
designation that was.
Right,
placed on
within
these properties.
contextual overlay, its maximum height is 27 feet.
Okay, and that one I'm
Or
less
average of-
comfortable with messing with, but the building footprint, because of what the chairman noted about the park, he doesn't get the benefit. That, I think, is a reasonable hardship. He can't get the benefit of the other stuff around him because they're not counting those houses that are across the street that are bigger.
Yeah.
Does that make sense?
What's on the screen now is the home.
Let me reinstate, the maximum height is 27 feet over average of 2 or 4 adjacent.
Okay.
Yes, because in his case, the 2 houses are 1 story, that's why he gets 27. If
Okay.
next door
So
has.
both of them impact it, is what you're saying?
Correct,
Okay,
correct.
I didn't know that.
So
Thank you.
if they have a 2-story house, his height will go up
Okay.
based on the calculation.
So are you saying that the 27 feet is contextual?
Yeah, contextual overlay
And it's
with
based-
his calculation, because his next door 2 houses is only 1 street. So actual average will be much lower than, 27 feet. But because their average was lower than 27, in that case, within contextual overlay, they're allowed to go as high as 27 feet. But if next door, by any chance, they have 2 32-foot houses in his next door, his house can go to 32 feet.
Okay.
Yeah,
So the same reasoning then applies that if,
does.
okay, that's what I was, all right, yeah.
Yeah, Ms. Davis, this is the home that the gentleman testified to the north, the larger of the 2 across the street. You can see the numbers here. Let me see if I can zoom in on that for you.
What, yeah, they're kind of small, is that,
Thank you for zooming in.
yeah,
See if we can get in there.
So
I mean,
it's-
yeah, you're looking at, 1367 on the main residence and 532 and 684 on this right here to the side.
Okay.
Now, it's just footprint. They don't do floor area, but, I mean, there you're at 2,400 square feet in that.
so it's
Footprints
about the
change.
same square footage as the contextual requirement.
It does. In the overlay, we don't cross streets.
Right.
And it's,
But I mean, I guess,
yeah,
yeah.
maybe the council should look at that. I don't know.
Joey, can you go back to the first, I'm just seeing the delta between the average to requested footprint, it was like 24 to 30.
This house is already built.
No, he's got a different
Okay.
case up. I was
I've got
kinda
another
confused
case up
too
there.
at first.
Let me,
I didn't think so, but Joey put that picture up and I'm like, did I miss something? Is that my
Yeah.
packet?
I'll get there eventually. Let's see.
I do think, so I don't like, y'all know, I hate messing with contextual overlays. It makes me sick. But I will say, I do think because this street dead ends at Shelby Bottoms Park, that does create I think that's a unique condition of the land that creates a hardship, so the location of the park. So I do think there's some variance that's probably need it. I was gonna rely on my architect to tell me if this is a, this is a reasonable request. And Joey, based off of the other houses in the area.
So 42%.
Well, I think so.
Okay.
Based on that hardship, and I think there's evidence, two structures on that site. I know one was a garage, but homes have garages, and so I feel like there's precedent for more on that site than the two neighboring properties. Does that make sense?
Yes, it is. Is that a motion?
But, hold on.
Go ahead.
No, we'll keep going if you had.
No, I mean, I agree. There's certainly a hardship, the fact that it backs up to the park and everything else. But, you know, he's asking 3 feet, you know, more than contextual overlay, but, you know, from a percentage standpoint, 42% more than what is, you know, is allowed. I don't know, you get into this ambiguous.
Are you talking about the height, Robert?
No, the footprint.
Yeah.
It's footprint, it's 42% more, right? So, you know, where is this line that you say, okay, well, you know, I don't know if we can dictate the percentage difference or you know, I think it has to be binary, yes or no. And I certainly agree that there is a hardship, given the fact that he only has 2 houses and not 4. But I feel like that's just a big ask. Maybe that's just my perspective.
I mean, I actually agree with you. I thought that too, but I also think there's a hardship, but I'm not great at crafting. Does that make sense? Like, I don't know how to craft it to make it.
Yeah, I'm, you know.
And sometimes we avoid that just because we
Exactly.
deal with
Exactly.
what
I
they
don't
bring
wanna-
up here, because if we tried to craft too much, we could be up here for hours at times. I mean, that's the way sometimes we do it. I think we just do it on a case-by-case basis, but,
And depending on the facts of the case and the
Right.
context, I agree with you.
Yeah.
I mean, it's a third over the contextual overlay. Or 42%, which is more than a third, so it's,
In between a third and 50%, it's in between that.
yeah.
Yeah, I mean, you know, height and setback are kind of more, in my opinion, than like overall footprint, because that doesn't really, it's not necessarily injurious of neighbors. But, I don't know, I'm not seeing a lot of other homes of that scale and size, but, I mean, a footprint too, especially a footprint of 3,400 square feet. I mean, you flip that over times 2, that's a 6,900 square foot house. I mean, a 3,400 square foot footprint house is huge. It is very, very large. But again, you know, that's just a matter of my opinion. So that's
Well,
I feel like it's a far reach, but
I think what would be helpful, if the applicant were to ask, you know, he referenced the house size across the street, and then calculate average of those within the contextual overlay. So in that case, my feeling, I have not calculated yet, I have a feeling it will not go as big as 33,100 square foot. So it will may not be, 24, 40 as a contextual overlay state, but somewhere in between what he's asking and 24. That would be my average out, will be kind of reasonable ask, because that's the reason for the contextual overlay. It's not too large, too tall, or whatever the case might be. So footprint as large as that is maybe kind of outside of intent of the contextual overlay. So I think we need to be kind of careful about, what we allow that.
yeah, I agree, it's a big footprint. So I think what you're proposing would be, the way we would accomplish that is deny the application as it stands today, but let the applicant know that we're amenable to reconsidering it with information about if you consider the 2 houses across the street, what does that give you?
So then maybe we would defer it and ask the applicant, so
Right,
he doesn't have to pay the
better,
refund.
yeah,
We would
yeah.
make a motion to defer it and ask the applicant to
Right.
bring more information about the other houses.
Yeah, great point, because if we denied it, I think he has to go back through the whole process again, so, that's right, so we could defer it, and Okay, I'll make a motion that we.
I think Mr. Ransom, I'm sorry, he had
I just
something.
want to make one comment to the applicant here is that, I mean, obviously there's the footprint component of it, and we understand why that is being requested, but I don't understand the additional, I mean, it's 3 feet, right? But I don't understand that unless he has a set of plans that he's just working off of.
Okay.
So if we're going to make a motion to defer it, I think having some additional information would be helpful.
Yeah, I mean, I think we probably want to see a new site plan.
And just, it would help, so for the applicant, I hope he's listening, we do think that you get a variance. We just need a little bit more information. We'd like to see the 2 houses that typically would be included but weren't included. And then it looks like Mr. Ransom wants more information about the height.
Yeah, if you have you have a footprint, that doesn't necessarily mean you have a schematic set of plans, but anything like that would be helpful.
Okay, with that, I will make a motion that we defer for probably, well.
We can ask the applicant when
yeah,
he thinks he can
here
get
if we
it.
open the public hearing again. Okay.
And just
How
for the,
long to gather up what we've asked for and put together a new site plan, how long do you think you would need?
Not long. I can get my surveyor and architect to get it as soon as we could.
So only one, next meeting?
next meeting is 2 weeks from today,
2
and
weeks from today, does that work?
2/19 and 3/19 are our next meetings.
So are you sure that's enough time with all the stuff that's going on and they're backlogged and stuff? Okay. Okay.
Okay, well, no, if you don't, we can probably defer it again too, so, but I'll make a motion that we defer it till the next meeting.
I second.
February 19th. Okay, motion second, any further discussion? All in favor? Okay, that motion passes.
Okay, Mr. Chairman, just for my assistance, so you would want him to compute the 2 houses across the street into
Yes,
the
I
map?
think that's what I
Okay.
understood, yeah, that,
Okay. All right.
yeah.
No, it's just, it was just to honor existing context.
Okay. All right, Mr. Chairman, our next case is case 2026-18. Ms. Dawn Kennard is the appellant, Become LLC, the owner of the property at 2115 10th Avenue South. Ms. Kennard is requesting an item A appeal challenging the zoning administrator's denial, cancellation of zoning permit in the R8 district, referred to the board under section 1740-180, item A. The appellant has alleged jurisdiction under the same section. I see the applicant and her counsel is here. Are there any other parties in support of the applicant's request present? In support, okay. You guys, and Mr. Cooper as well, if they wish to speak, it'll come in this phase of the 10 minutes. So I'll let you guys work out your timing on that. After they speak, I'll come and give my side, and like you saw the other, and there's legal representative of a neighbor present who'd like to address in the third part, and then Mr. Cooper will have the rebuttal opportunity once we're all done. So, just a brief overview, a little bit, high level. Why we're here, we had issued a. Ms. Kennard was operating a hair salon at 2115 10th Avenue South. The legislature in its session in 2024, excuse me, passed a statute that permits hair salons to offer for sale or consumption of alcoholic beverages and I'll just read from the bill itself. What the state classifies as a restricted retail business means a retail business that is a barbershop licensed by the Board of Cosmetology and Barbering, a cosmetology shop licensed by the Board of Cosmetology and Barbering, or a cigar bar that provides food service to its patrons, has no more than 20 seats for food service for patrons, and sells alcoholic beverages for consumption on the premises in an amount of sales which do not exceed 15% of the retail business's annual gross sales. Other parts of the code that are amended restricts the sale of those beverages from not to be sold from 10 p.m. to 8 a.m., puts a dollar amount as far as licensing for that. let's see, looking at the last section here. The sale or distribution of wine, beer, or liquor, or any alcoholic beverages or drugs on the premises of a cosmetology, manicuring, or aesthetics establishment that is not licensed as a restricted retail business as defined in TCA 57-4-102 by the Alcohol Beverage Commission is prohibited, provided that wine, beer, liquor, or alcoholic beverages may be served to a patron without charge, but no such beverage may be served to a person who is intoxicated or believed to be intoxicated. So, long story short is Ms. Kennard operated from our perspective as personal care services, which is what we classify hair salons. I have applied this state law to say that those establishments can serve alcohol to their patrons for the customers being served by the salon, be it nail, hair, whatever. What was alleged in a complaint to us is that in addition to that, that she is operating a freestanding wine bar on the premises, in which that's what's brought this to a head, is my determination that the wine bar is a separate use and should fall under bar nightclub. She disagrees that, no, this is part of the hair salon business as spelled out in the state statute. And so that's the gist of the disagreement. Is that a fair assumption? Okay. So I'll turn over to Mr. Cooper, not to get into my time, but I'll give you my reasons for why I settled where I did after he and the folks in support are done. So with that, Mr. Cooper, after introductions, we'll start the clock on you.
Thank you, Mr. Chair, members. John Cooper, Holland & Knight Law Firm, here representing Don Kennard, who is the owner of Fine & Pico at 2015 10th Avenue South. We are here today asking you to reverse the zoning administrator's decision that Fine & Pico is operating as a separate bar instead of a salon. So that's the crux of the matter, is whether it's a salon or it's a salon and a bar. We believe that Mr. Hargis, while he did acknowledge the state law and read the provisions, we think that that's a narrow interpretation of the state law and is not consistent with how the state interprets it and other regulatory agencies. Ms. Kennard has compiled a binder that you have in front of you with all of the relevant approvals and documentation related to this use. I will refer to a few of those documents in my presentation and would ask that binder, we provided extra copies, ask that it be made part of the record. Mr. Hargis briefly discussed the history, but this salon or this building has been used as a salon for decades. It is a historic building, and while it is residentially zoned, it is a legally non-conforming use. In January 2020, Ms. Kennard obtained a zoning approval and use and occupancy permit for her to operate the salon. The state law change that Mr. Hargis referenced came about in 2024. Then in 2025, Ms. Kennard obtained the approval from Mr. Hargis to operate a food and wine accessory use to the salon in accordance with state law. A couple months later, the zoning administrator determined that this was operating as a separate and distinct bar and not as part of the salon use. I've included copies of the statutes that Mr. Hargis mentioned as, they're listed as item 23 in your, at the very end of your packet, if you want to review those. He did read them. But these statutes created 3 special categories of businesses that can have alcohol sales as an accessory use. That's a cigar shop, a barber shop, and a salon. The statute provides that if a barber shop or cosmetology salon has a restricted retail business liquor license, and that's very key here, through the State Alcoholic Beverage Commission, then the salon can serve and sell alcoholic beverages to any patron. There is no limit in the state law that it only be sold to those who are getting a haircut. It's only when the salon does not have this restricted retail business liquor license that the salon is limited to just serving or providing to salon customers. The statute sets out 3 primary criteria that must be satisfied in order for a salon to sell alcohol as a retail restricted business. First, you have to have food service. Second, you cannot have more than 20 seats. And 3, it limits alcohol sales to no more than 15% of gross sales. And this interpretation has been confirmed with the state. Before operating as she is now, Ms. Kennard sought and relied upon guidance and approvals from the various appropriate state and local authorities. She obtained zoning confirmation, a use and occupancy permit, health department approval, fire marshal approval, Metro Water approval, and this is very important here, a Metro was approved 31-0. She also obtained beer board approval and a valid and active state alcoholic beverage commission license. So this case did not arise from a change in use, but from an assumption that because alcohol was being sold when no haircut was occurring, that accessory use had transformed into a standalone bar as a separate use. However, we do not believe that assumption is consistent with how the state law and the regulating agencies have treated operation of this and similar businesses. As part of the enforcement action against Ms. Kennard, Metro Codes referred the operation to the Tennessee Alcoholic Beverage Commission. The commission issued 2 formal records requests, which Ms. Kennard fully complied with, providing financial records, point of sale data, and reporting documentation. The ABC, Alcoholic Beverage Commission, issued no violations, made no findings or corrective actions, and imposed no conditions on the license. So her license remains active today. Both the health department and the beer board have confirmed that service of food and wine to persons not receiving haircut is permitted within the approved space. I think part of the confusion here.
Who has approved that? Say that again.
That was through your discussions, and Ms. Kennard can speak more to this, she had discussions with both the health department and beer board.
Okay, is there anything in writing where are you saying?
Yes.
So the beer board
The beer board, yes.
has said in writing that you can serve to people who are not there.
Yes, I have that.
For a hair, and I know it's more sophisticated than haircut, but I'll just say haircut. You've got something in writing from the beer board that you can serve to customers who walk in and don't want any kind of salon service at all?
Correct.
Okay, and is that part of this record? Do you have that?
Yes, it's in here.
Okay, can you tell me what tab that is, just so I can?
Yeah,
There's a table of contents.
I have,
You may have your own.
This right here, I
You've
could just
got
bring this
right
up.
here, yeah.
Got it.
It's
Which one is it?
tab 3.
Okay,
That's Pamela. And this
which,
one.
is it the,
Tab 3 and
is that the November 7th,
The beer board is a different one.
I think it's tab 3 for the health department, and there's a separate one for the beer board that she submitted. Yeah, that's under tab 6. Second page of tab 6.
okay, but I don't see in here where they say, we are okay with you serving to people who are coming in and not utilizing salon services. I see where
Yes.
they're saying, as long as you're serving a person who's over 21, and the person that is covered under your beer permit, there shouldn't be any issues, but I don't see them
Yes, the
saying.
question that I had asked when this was brought up was just, do people need to be getting a haircut to buy a drink? Because I was told from the health department that anybody could come in and buy a beer, and that's in writing as well.
That's what I'm trying to, if you have a copy of the writing.
Yes,
That was, I think, the three, right?
Because what I'm seeing behind tab 6 is not a writing from the beer board saying that that's okay.
That's, yes, when I asked the question to the beer board, he said, as long as you're serving a person who's over 21 and not intoxicated, and within the footprint that is covered under your beer permit, there shouldn't be any issues as far as the beer board is concerned. The beer board set up my area with the 20 seats. They told me where to put the bar, where to put the hand sink. These weren't decisions I made on my own. I just followed their guidance on how to set up this accessory use.
Okay, I'm sorry to interrupt you. I just wanted, when I heard that, I wanted to kind of drill down on it before I forgot.
So I think part of the confusion is that the health department, and that is included in tab 3, incorrectly said that the alcohol portion needed to be a separate entity, and as well as the interior configuration, but this is just one business. And again, this interpretation was confirmed by Senator Johnson's legislative analyst. Senator Johnson was the sponsor of the bill, and he confirmed that the intention was to be able to serve to anyone on the premises, whether you were receiving hair services or not. Ms. Kennard would not have gone to the trouble and great expense of going through this process if it only allowed alcohol service during a haircut, because she could already provide wine or to someone who was getting a haircut for free now, without having to go through that process. The evidence that the zoning administrator has relied on is, first, if you look at it, they're different colors. So you've got the salon and then the wine bar. Visually, it looks like they're two separate businesses. And Ms. Kennard is willing to paint the outside all one color so that it's clear it's just one establishment. Then there was a photograph taken in the bar area while lights were off in the salon. Again, we submit that's not a violation of state law. The photo was of a birthday party being held there by area neighbors. There's no requirement in the law that it be limited to those just receiving salon services. The salon often has hair appointments into the evening. It is a appointment-based only salon, and the stylists come and go throughout the day and schedule clients, as fitting for both of their schedules. Ms. Kennard has submitted 22 emails from area residents and 30 signed petitions in support that's listed in Exhibit 20 and 21.
Including the adjacent.
And that does include the adjacent neighbor to the establishment. You did receive a letter from Mr. Murphy, arguing, representing a neighbor, arguing that the salon is not a lawful use of the property because it's zoned R8, and that even if it is, alcohol sales are not allowed since it's a non-conforming use. But as I've stated, that's inconsistent with how the state law treats these establishments. We do not believe this is a change in use. Rather, it's an accessory use to the salon. And again, the hair salon was expressly permitted as a non-conforming use by the zoning administrator, and a certificate of occupancy was issued in 2020. That's Exhibit 4. Mr. Murphy also argues that it's if it is allowed as a non-conforming use, then the wine bar became a second primary use. Our position is that it is an accessory use, and the state law is clear that the wine bar is considered an accessory use to the salon as long as all the statutory requirements have been met, which this one does. The letter also references noise concerns. Those concerns can be addressed by the noise ordinance, which applies as if this property was a residence, so there is a mechanism for addressing that. The letter also references the outdoor porch area as being a concern. This is not a new area. It's been used as part of the salon services. It's for Brazilian blowouts, which I've never had, but you can have one done on the porch. So again, we're not asking you to approve a new use. We respectfully request that you reverse the zoning determination reclassifying the approved accessory food and wine service as a separate bar use, We also ask that you direct that the stop work order that was issued in connection with that be removed, and confirm the zoning eligibility of the beer permit to operate as an accessory use within the existing salon. And I'll reserve the remainder of my time, please.
Okay, any questions?
I have just one. Going back to what our chairman was asking in reference to something a little bit more specific about the use or the sale of alcohol to people that aren't getting, some type of salon services. You directed us to tab 6 that had an email from the beer board. It says, "Hi, Dawn." Do you have the email that Dawn wrote, referenced? I'd love to see what her question out was.
I don't have a copy of it here, but I could get it.
Yeah, if you could pull
I'll go
that
grab
up.
my phone, see if I can find it.
Just want to see the question that provoked that response. That was my only.
Might take you a bit to find it.
Yes. Well, and the senators, with the letter, also,
Yeah, that's also under tab 8 is where you have the analysis from the state
clarifying.
senator's office, clarifying that specific question.
Is that behind tab 8?
Behind tab 8,
Is that Luke Gustafson?
yes, that's,
The author of the bill.
he
says-
wrote the bill for Senator Johnson in his office.
And he says essentially it's an accessory use. They don't have to be there for salon services.
Correct.
Yeah, specifically, it says, because the shop has the legal authority to sell alcohol, any adult who lawfully purchases alcoholic beverages on the premises becomes a patron of the business, regardless of whether that individual is also receiving hair or cosmetology services at that moment.
When these concerns were brought up, the beer board and T-BAC came back and re-inspected the shop and found no problems, so.
So the operative statute here is 574102, and you are restricted retail business, correct?
Yes. And have to,
Under 34A, small I, correct?
correct.
So, but you don't provide food service for salon patients, correct?
Yes, if I actually have a bartender, it's only, the bar area is only open a couple evenings per week. So if I have a bartender, then I can get food from the bar or drinks from the bar. So if a client is there in the evening, they get a menu from the bar. The clients get a complimentary drink with a hair service, so they can choose one from the menu if a bartender is there.
Okay, anybody else have any questions? Sorry to hold up. Okay, well, you've got some time on a rebuttal, obviously. Okay, so the opposition, there is opposition here, is there not?
Yes, sir. I'm next, and then
Okay.
Mr.
All right, yep.
Let's see here. Ladies and gentlemen, Joey Hargis, Metro Zoning Administrator. All right, let me pass out truths from not full stories that I heard there. Truth, we did write to the beer board. We signed off on zoning approval, and my approval of her beer permit is contingent upon the entire notion that the folks getting the alcoholic beverages are patrons of the hair salon, not any Joe that walks in off the street. With all deference to Mr. Gustafson, if that's what the legislator wanted, they should have wrote it in the bill. It's nowhere in this ordinance does it say that any person off the street becomes a patron of the hair salon. Not at all. If that's the intent of the legislature to override local government from applying zoning regulations and land uses, especially to land uses that are legally non-conforming under 13720A of the state code, they ought to specify that. They know where to do that. With all due respect to this fellow and Senator Jack Johnson, if that was what the senator wants, then the senator should follow the plain language statute and say it. That's not what he does here.
So that's the beer board permit issued by Metro that you're holding up?
What I'm holding up is the state statute
State
that
statute.
gives hair salons and cigar bars
The
and
restricted-
barbershops the ability to sell or
Right.
to provide alcohol to their customers.
But you're saying the Metro permit was issued
The Metro permit, whenever the Metro
on the
Beer Board,
basis that it would only be served to
that's right.
people that were salon
Yeah,
patrons?
that's the entire, when the beer board issues a beer permit to anybody, they have to check with zoning, like, are they zoned for this use? Are they zoned for a bar? Are they zoned for X? And our entire approval is based upon only the patrons of Miss Kennard's are getting served, not people walking in off the street. I mean, to me, when I drive from Gouldsville out here to this place, walk into the business that's clearly, and I'll show you the photographs, looks completely like a different tenant. And I'm to believe that's not a bar, that's a hair salon? Well, let's get into the photographs that I'm gonna show you as part of the record.
But I'm going back, so the permit issued by Metro
In
was-
2020.
was conditioned on alcohol sale being limited to salon patrons.
It's conditioned upon zoning approval from the codes department, and my approval from this department
Is
is,
based on
is
that.
based upon that these are patrons of Miss Kennard's getting
Okay,
their hair
all right.
done or their nails done. Not just anybody walking in off the street. And that's my issue. So here's the first photograph in my thing. I shot this yesterday. There's nobody, no reasonable person can look at this building and say, oh, that's a hair salon. You know, they're two different colors. This is the way it looked last year in April of 25. Single color, says fine on it. This is when we issued her a permit. This is a hair salon. I told her at the time she came to see me, hey, yeah, this is fine. You can sell or give away alcohol to your customers, but you can't do this. You can't do this. This is a bar. And to sit here and testify that this is an accessory use, I'll tell you, members, this accessory use swallows the whole. This is a separate principal use. This is a photograph my inspector took on January 2nd at 8:27 p.m. There's not a soul in the hair salon portion of this business. I can't get through the right-hand side of the building to the left-hand side of the building. There may be a door in there, but there's not intermingling between the two spaces. These are two distinct tenant spaces. This is an Instagram post by the applicant sitting before you. She says, Paul and Betsy have poured their hearts into this space, the wine bar, and tonight you get to share it with you. They're holding themselves out as a separate tenant from the hair salon. They're saying, we're a wine bar. She's a hair salon. We're a wine bar. Here's the same photographs from the night of January 2nd. There's not a soul in here cutting hair, guys. Not one. How in the world can this be an accessory use when there's a room full of people on one side and nobody getting their hair cut on the other side? Here's the back of the building, later in the same month. This is accessory to the hair salon? This swallows the whole. This is the principal use. See this nice sign that says Happy Holidays? That's covered up over my stop work order that says removing this is a violation of code. We're taking her to court over this violation. We posted a stop work order back in December. She continued to operate through it. She completely disregarded our stop work order, didn't cease operations, kept right on trucking. right out there trucking today. You know, they're out there operating right now. So I'll submit to you currently, we logged in on Instagram. Here's her current Instagram post. This is live right now. Pico, Nashville, a neighborhood wine bar. They're telling you what they are. So I'm not supposed to believe this? Oh no, this is just part of the hair salon. This is their wine bar. Everything in here talks about the wine bar. There's no relevant discussion in any of the Instagram posts that it has anything to do with the hair salon. So yeah, I revoked her permit. These are two separate tenant spaces. I believe, I do disagree with Mr. Murphy. I think there's a legal nonconformity here for a hair salon, but I'm open to listen to Mr. Murphy's arguments that there's not. But to sit here and say that, you know, the wine bar is somehow separate, you know, she mentioned in her own statements just a second ago, she said, if my patrons are here later, they get a menu from the bar. The bar's next door. You know, these are two separate freestanding uses on the property, the only one of which is legally nonconforming in my opinion. And I think the state statute is not clear at all. In due deference to Mr. Gustafson, nowhere in tab 9 do we get to see the question that Dawn asked him. I have no idea what she asked him. Couldn't tell you. He agreed with her, whatever it was. Tab 6, she's asked the beer board a question. What's the question? I have no idea. Context matters. I only get bits and pieces from this applicant, and that's my frustration if you hear it in my voice. I've been clear from her from day one, and it's she's, thankfully, tab number 12, puts it specifically in here what I told her. She came to me and sent an email. I wish to withdraw my case, Mr. Argus, what I need to do. And I said, Ms. Kennard, since you added your lawyer, I'll add mine. And I said, here's what you need to do. Halt all operations of the Pico bar and remove any demising walls between your salon space and that area. A, the use of the bar is prohibited in that zoning district. Court proceedings against the operators of the bar are forthcoming, and they are. My lawyer's here that represents the Code Department. We are in environmental court against the operators of that bar. I've revoked the zoning approval to the beer board based upon my opinion of fraud. It was to me, we're supposed to be, I'm serving the patrons of my hair salon. You can see in the photographs, that's not what's going on at all. And I've told her in point 2, being in compliance for zoning means that your customers in the salon may be served alcohol in accordance with the state law. With all due respect to Mr. Senator Johnson's staff, if they intended any Joe to walk in off the street, they should have said so. But this bill effectively guts local governments from having zoning regulations and regulating land uses.
Well, but I don't think the bill does, because doesn't the bill still allows the local zoning authority to determine whether a permit should be issued or not, correct?
Absolutely. And I don't think as to say that the hair salon allows them to serve beer, local governments could take the position, great, if you're serving alcohol, you're now a bar, you're not a hair salon anymore. I mean, that could be the position we take.
I know you have, in this email, you've revoked the zoning approval for the beer permit. Has the beer board done that too yet, or?
To my understanding, yes. Okay. Mr. Darby had passed along to me that they would, she was operating off a temporary, and that my to her is that we would draw our approval for the next renewal based upon the outcome of what happens today. If you guys disagree with me, great. We'll reinstate it and we'll go from there.
Well, if the beer board has revoked the permit, what's the, I mean, isn't this just an enforcement matter at this point?
Well, it is from the beer board's point of view. He asked me in the email, which I've given you a copy, Joey, does the revoked zoning status prevent them from operating until the zoning review has been approved? They are currently operating under a temp beer permit, which expires 1/17/26. And I said, in my opinion, yes, they have filed an appeal to the BZA. I would not renew their temp until this appeal's finished. Okay. Until we get some resolution from this. Because for me, the beer permit, my zoning approval for the beer permit is contingent upon this being accessory use.
Right. Yeah,
and serving the patrons getting there, not any Joe off the street or any birthday party that wants to reserve, you know, a third of the building or half the building. You know, to me, guys, this is, in my opinion, it's just not a hard case. I mean, she has two separate distinct land uses occurring out here. The salon's fine. serve alcohol to your heart's content, but you don't get to have a freestanding bar that does, you know, stuff like, that you don't get to do this. You know, when this is going on one side, you don't get this. None of these people, I don't see nails getting done here in this photograph. I don't see any hair getting done. Mr. Cooper says, well, the state law doesn't require it. I'd beg to differ. The state law talks about patrons. If they don't mean the patrons of the salon, then what patrons are they talking about? So, anyway, that's the balance of my argument, board, is that, with that, I'll stop talking and answer any questions you got of me. I would love to see the questions that Ms. Kennard sent to these two entities, because I think that truly matters. But I'll say to you this, quite frankly, I don't care what the state senator's aide has to say. He does not enforce the zoning regulations in this county. So if they want to change the law and preempt us, go for it. They're happy to do that anytime they want anyway, so.
Joey, could you, I'm looking all over for that state statute that you held up. Where is that?
Tab 23.
For submittal, I think I've got a copy. I'll pass out to you guys.
Yeah, I saw this, but maybe this is the meat.
It's the same thing.
Is this the meat and potatoes of it?
Yes, sir.
Yeah, okay. Thanks.
All right, with that, I will
Are you done, Mr.
I'm done, yes, sir.
Okay,
Unless you have
so-
questions for me,
okay, I think
I'll
Mr.
reset the clock for
Murphy
Mr. Murphy for 5 minutes.
Mr. Chair and members of the board, Jim Murphy, Bradley, I represent Chris Chappell, who lives at 2113B, 10th Avenue South, which is immediately across the alley from this property. We've also got an additional neighbor who's also opposed. But I really want to focus on what the issue is here, because I think, Mr. Pepper, you just hit the nail on the head. This state statute that we're talking about is irrelevant for zoning purposes. It gives them the right to have a beer permit, or, an ABC permit from the state to sell liquor. That doesn't make it an accessory use for zoning purposes. Zoning purposes, it's governed by Metro's zoning ordinance. The state statute does nothing to change, alter, or permit anything for zoning purposes. It's just a liquor legislation. It just determines whether they can get a liquor permit in a salon. Yeah,
From the state.
but they still have to comply with zoning. Mr. Hargis just told you, they have to ask Metro, do they meet the zoning ordinance? If they don't meet the zoning ordinance, then they can get a state liquor permit, they can get a beer permit from the beer board, but if they're not in compliance with zoning, then the fact that they can get a beer permit or a liquor permit is irrelevant. So all the discussion about what the state legislature's done is just a smokescreen to avoid the real problem here, which is this is either an illegal use or a legally permitted nonconforming use that has been altered without coming to this board first, which is required by the zoning code. The zoning code is more liberal than the state law on legally permitted nonconforming uses, because the state law doesn't allow you to change the use. Metro's zoning code does permit a change in a nonconforming use, but you have to come to this board first, and you've got to show that the nonconforming use is more compatible to the neighborhood than the previous use. Well, here, there's no question, and we've put in an affidavit from Mr. Chappell that demonstrates that prior to the addition of the wine bar, this salon operated roughly up until about 4 o'clock in the afternoon. And now it's operating till at least 10, and we've got examples of them operating as late as 10:45. So they're operating later in the evening, which has a whole lot more significant impact on the residences in the area than a salon that closes at 4 o'clock in the afternoon. It also increases the traffic and it increases the noise, as Mr. Chappell's affidavit said. So it's hard to understand how they can show that the change in the non-conforming use is less impactful on the neighbors than the prior use of the hair salon. Mr. Cooper says this is a legally permitted non-conforming use because it's been used for a long time and Metro issued a certificate of occupancy. As I set out in my letter, none of those things matter. In order for the applicant to show that this is a non-conforming use, they have to show it was legally permitted prior to the time that the zoning ordinance changed to determine, to basically make it no longer legal. This property has been zoned for residential use since the 1930s. There is absolutely no proof in this record that this property has been used for a hair salon since the 1930s or any other legally permitted non-conform use that was legal at the time that Metro first the city of Nashville first adopted its zoning ordinance in I think it's in the mid-1930s. This property was zoned Residence A under the Old Cities Code, and the Old City zoning code specifically prohibited beauty salons or hair, beauty salons, I think is the term it's used in the at least in the 1941 code. That's the earliest one I've got. But the 1941 code prohibited beauty salons in the Residence A district. That prohibition of beauty salons in the Residence A district continued when Metro adopted its first zoning code in 1974. And then when the new zoning ordinance was adopted in 1998, the zoning ordinance did not permit beauty salons in, or as a permitted use in a R8 district, which is this. So there's no proof in the record, and they have the burden of proving it. The fact that Metro's issued permits in the past is irrelevant. The courts have said that's not enough. So for that reason, we contend that this is not a permitted use. It's been a change in the non-conforming use without the board's approval, and you should affirm the decision of Mr. Hargis. Thank you.
Any questions for Mr. Murphy before he's? Okay, thank you very much.
Thank you.
Okay, Mr. Chairman, the applicant has the time remaining for rebuttal.
Before I start the rebuttal, could we answer the question about what the beer board was actually asked?
I didn't know, was there a question pending on that?
Yeah, I had.
Okay, yeah. Can you repeat the question for the record, that way we're?
Yeah, so under tab number 6, there's a response from the beer board. Hey, Dawn, as long as you were servicing a person who was over 21, et cetera. And my question was, what was, much like Joey said earlier, what was the question? Like, there's not much context here.
I have the email here. I can read it if you, or you can look at it. It's
Sure, you can read it. Yeah.
Well, I mean, I can just tell you, you can read it, but the response says it all to me, which is I don't have any affirmation here from the board. I mean, regardless of what the question is, there's a way to give an answer to something without answering it directly, but go ahead and read it, I'm sorry.
Hi, Doug and Terrence. Thank you both again for your guidance and support through the council resolution process. It really helped me navigate everything smoothly. I just had a quick clarification for my notes. Under our restricted setup at Fine and Pico, is it acceptable to serve a beer to a nearby neighbor or guest who isn't receiving a hair service, as long as we stay within the permitted hours and follow all standard requirements? ID checks, posted signage, no service to intoxicated persons, ? I just want to be sure we're following everything exactly as intended. Thank you again for all your help and for being so great through the transition from our temporary to official license.
But so the question is, even if the beer board takes that position, I mean, Mr. Hargis's position is the beer board had to get permission from zoning to that this was a permissible accessory use, and he gave that permission because it was on the condition that it only be served to patrons who were there for salon patrons. So, I mean, even though the beer board may say that, doesn't it all fall back to what the zoning determined about the conditions upon which the permit would be issued, which was, their position was, in other words, when the beer board came to Metro and said, do you approve? They said, we'll approve as long as you as long as it is only served to patrons that are there for the salon.
They didn't
Doesn't it
say
all
that.
That
come-
was not said, though. I think that's the issue. If that had been said at the time,
I never would have applied for the license.
I think that's what I understand Mr. Hargis to be saying, is that whether it was said or not, the approval for Metro, their understanding is you would be in compliance if you just served alcohol to salon patrons, which is I think a reasonable position for them to, I mean, why would they believe why should zoning believe that you're gonna have a separate customers to whom you're just gonna serve alcohol to that weren't there for salon services? So I guess what I'm coming back to, doesn't it all fall back to whatever the beer board says and whatever the state says? If it's not okay with zoning, then it's not okay.
right, I mean, our position is that it is okay with zoning because it's an accessory use to the salon as identified in the statute. I don't think we can say that the statute is irrelevant because the two go hand in hand. If you're permitted as a salon and you're appropriately zoned and you get your license through the Board of Cosmetology.
But
then-
how is it an accessory use when it's marketed as a separate bar? And I'm gonna ask my question, then you can answer it. How is it an accessory use when it is marketed as a separate bar, and even the pictures that we saw, it looks like a separate bar? So how is that an accessory use? Because within my mind, that's not accessory. Accessory use is secondary to the primary purpose, and the primary purpose was a hair salon.
I would answer that two ways. First, the state law limits the sale of alcoholic beverages to no more than 15% of the gross revenue of the establishment. That's not much. I mean, the primary purpose and the business operation is the salon. We will acknowledge that the way it looks now, that needs to change. It needs to be painted back to one color. The reason it was a separate space is because the beer board said it had to be. That's the reason it is, cornered off, and said that it needed to have its own name. So she was getting conflicting information throughout the whole process. So I think that's how I would answer that question.
How does this may be for Mr. Horace, in our Metro zoning code, where is the definition of accessory use? Is that in the general provisions and definitions? Yes, here it is.
Yes, sir.
Accessory use means a use of land or of a building or portion thereof that is customarily incidental and subordinate to the principal use of the land or building, and that is located on the same lot as the principal use. I mean, and I think the point here is, this is not an incidental business if this is a separate business. It's supposed to be incidental and subordinate to the principal use, but it's just like a whole nother business. I mean, if you're not even operating the salon at times when people are in the bar drinking, how is it incidental and subordinate to the salon use?
That was a picture that was taken in a moment, but hairstylists work as late as 9 p.m. So, and
Well, I mean, the
people do
evidence
walk
is
back and
pretty-
forth, there's a door
I
between
mean, the
them.
evidence is pretty clear to me that there's wine and beer service when there are not people there that are getting haircuts. I mean,
Well, if hairstylists work up until 8, I mean, the license says you're allowed to serve alcohol till 10 p.m., so it's within the rules of the license to stay open a couple hours after the salon ends, basically.
oh, you've still got time left. That was my question. Thank you.
I think I've addressed what I was going to address. Again, we think the statute is relevant. The question about the non-conforming status as a salon, I mean, that's just now come up. I mean, it's been a commercial business forever. So we don't think that's a relevant argument. And again, the beer board required the separate space. That's been the problem. I think if we'd gotten some different answers, or if Ms. Kennard had gotten some different answers on the front end, a lot of this could have been averted or resolved on the front end, but she.
Well, it's a separate space, but, I mean, it's not like it's just people that are drinking in the separate space or salon patrons. I mean, you'll concede, won't you, that there are people in the separate space that are drinking that are not salon patrons? Is
Yeah,
that
but
fair to say?
There could be people on both sides. We're planning to do book clubs on the salon side.
Right, but you've got people that are there to drink that aren't there for salon services.
It's foot traffic. Nobody's coming there from elsewhere, but if a neighbor wants to stop in, I mean, it made the picture look like it was crowded, but there might have been 3 people in that picture, that are actually in there. And you do have to go into the salon to go to the bathroom. It's connected. All the wine is in the salon side. We weren't given any rules on what the building was supposed to look like. And during the setup, TBAC and Beer Board sends you to the health department. They're the ones who set you up, basically, with this new bill. And so she told us exactly where to put the bar, where to put the hand wash sink, how to put the stools. These are the hours you can operate it. Yes, neighbors can stop in it's like a proper accessory little area, like in my mind, like a Starbucks inside of a Target, but it is one business. But the license is very expensive, so to only give, clients have always received a complimentary drink with their hair service. And so it wouldn't make sense for me to get this license if I was only I'm not gonna sell a glass of wine to a client that's spending $300 on their hair. It's a perk. I wanted to make it where the salon feels higher end, just to have this perk of this being here, where they could have a snack, they could have a nicer glass of wine than box wine, and a selection. And so it does elevate the salon environment, and the appearance can be changed. I initially asked Codes when he brought this up, I was gonna do more to the building to make it cohesive, and basically just ran out of money, but I wanted neighbors to know something was different, so just painted that part green to know there was another service there, and was planning in the spring to sort of finish the exterior. And when this came up with Codes, I offered to work with them on what they would want it to look like to make it cohesive, because it is 2 different services. The building's historic, and it was originally 2 businesses. The wine bar used to be my shampoo room, so I'm happy to make it cohesive. In the application process, they said, what is the name of the bar? So I just assumed that bar was supposed to have a name. So I thought by leaving fine up in the middle of the top of the building and just like a tiny writing on the door, that it made it clear that it was still part of the building. And neighbors seem to know it's part of the building. I think it's, a new bill, and it's a bit of a misunderstanding with how exactly it's supposed to look. So.
You've got some time left too, and there may be questions too, I don't know.
I think we've covered everything in responding to the questions.
Okay, thank you all
Thank you.
very much. Let me make sure there's no questions. There might be, okay. All right, thank you very much. Yep. Well, to me, it does boil down to, is this an accessory use or not? Whatever the beer board does, whatever the state does, Metro zoning gets to determine whether or not it's an accessory use. And so if I look at the deposition, and I will say, it is a little bit, in ways it's unclear, in ways it's not to me, but it's pretty clear to me that an accessory use means a use of a land or of a building or a portion of thereof that is customarily incidental. And I just don't think it's customarily incidental to a salon service or really many businesses that people offer drinks to patrons, and I think as the applicant said, or not the applicant, the owner, that's pretty customary, but what's not customary is extending that to, vending alcohol to people that come in, and even people that come in that are not patrons. And that's where to me, it's pretty clear it's not customarily incidental, it's a separate business. And I get what they're saying about that state statute is not exactly clear, but one thing is clear is that to get the beer permit, they want to make sure it's okay with Metro codes. And it was okay with Metro codes as long as it was going to be served just to patrons. But then when it was determined that it's gone way beyond that, then it's not an accessory use. And I get that part to me is really clear. So anyway, that's.
I'm on the same boat. I'm pondering the accessory use, either Metro definition or state definition, because this serving wine, beer to the premises of hair salon is allowed under the new amendment introduced by Tennessee State. But it says if you are serving the alcohol to the patrons, no charge. But this new amendment will allow charging as an accessory use. That's how I interpret it. So to me, that accessory use is you may serve the person within that main business hours, as long as you are providing some main service of haircut, manicure, whatever the cosmetology is. As an accessory, you may serve or sell wine, liquor. And so that's, to me, is accessory use. So while they're using, some people comes in to get the hair done, to get the nail done, and then friends comes with that person, and then while waiting, the other customer may consume a wine, beer. That's my interpretation of the newly proposed Tennessee statute. But this one is when serving alcohol, beer is totally different hour, a different location. So it does not constitute as an accessory use to me, no matter how I try to interpret. So for that, I don't think our administrator's interpretation was wrong. I don't see he erred by issuing stop work order, because it's completely two different use, not accessory use. Because bar and club, we do have a different definition, but seems like they're trying to get whichever fits on the Tennessee statute, and then metro zoning. And they cannot pick whatever the portion they want to use. They have to follow entirely. So I think this applicant is kind of pick and choose whatever fits their purpose, but it's not following through its entity as far as zoning law or as far as our Tennessee statute. So with that, I'm affirmed our zoning administrator did an error.
I agree, but I think, there's multiple layers to this, the requirements that the health department has, and, especially around constructing and separation of spaces and storage of food, transforms the structure to look different in some ways. So it's not like it can maintain, to be a salon, it's all wide open. You can walk there, sit in chairs, hang out with friends, grab some food, and it does need to be a separate space for health reasons. So because of that, there's some tenant improvements that almost push it into being kind of a separate space in a lot of ways. You know, they have to provide food, and that food has to be stored in a certain way, and it can't exceed 15%. But I also agree that it plays, you know, from the advertisement, you see it advertising itself not as a salon that serves alcohol, it's advertising itself as a completely separate space. So,
I think the health department, though, could require what it required and it still not be advertised the way that it was. Like, I
yeah,
think what
they're sort
kicks,
of pulling it.
I think the applicant likely had best intentions. I'm not gonna, I assume she wanted to do everything the right way, but I agree with the chairman. What kicked it over is just like, and I asked the same question, how is it ancillary? Ancillary is secondary. You can't say it's secondary when you advertise it as a separate business and you sort of painted it to look different. I mean, it sounds like they're gonna make it all one color again. They can advertise it as one thing. They can make sure they only serve and sell patrons. There's a lot of things that they can do to come in compliance with the permit that Joey initially issued and still keep it separate. I think separating it doesn't have anything necessarily to do with what the permit that was issued. So I agree that the zoning administrator didn't err. Also, like, covering up the stop sign like that, you're not supposed to do that. Like, you're supposed to, if they put up a close the business sign, that sign is supposed to be out there. You can't cover it. So I just think that there is a path to come in compliance with the permit that Mr. Hargis initially issued, and the way that it's currently being marketed and operated isn't in compliance with the initial permit.
Said much better.
Is that a motion?
Yes, that's a motion.
Okay, is there a second? So your motion is to?
My motion is that the zoning administrator did not err in his interpretation of how the permit was initially issued.
Okay, is there a second on that? Second. All right, there's a motion and a second. Any further discussion? All in favor, say aye. All opposed, okay. That's 5-0.
Mr. Chairman, the final case on today's agenda is case 2026-19. Concrete Investment, the appellant and owner of the property at 1711 A and B River Drive are requesting variance from the contextual street setbacks in R10 to construct 2 single-family residences on the property. Appellant alleged jurisdiction for the board under section 1740-180, item B. Is the applicant present? I saw him. There he is. Yeah, there's the applicant. Are there any parties present in opposition to this case? Okay. Mr. Nagoop, seeing none, let me just go through a little bit explanation for the board, and then I'll turn it over to you. The subject property is the pie-shaped lot, which you see here. It's I'd say it's the intersection, but it really isn't. River Drive over in West Nashville curves. So this is the curve, the lot in the curve. And 2-family residences in the zone in R10 require the setback to be the contextual homes down both down both segments of the curve. So if this were a corner lot, I'd look at the shorter of the 2 lot lines and I'd say, here's your context on this street, and then this street would be what the table says. But in this case, the 3-sided lot is, it's an arc. So his context is 48.9 feet. Yeah, 48.9, and they are proposing a 20-foot setback for both structures out on River Drive. Setbacks here along the side, 5-foot side yard along this line, 10 feet because of the public utility easement, which is located on the western part of that property, and then 20 feet is just from the point of the radius, if you will. This is looking at the current structure on the lot currently. Again, this is the curve of the street, so you're kind of looking down west on River Drive. There's the homes here, and then looking around the curve are the homes on this side. So when you take the context of those two, it spits out 48.9, which would leave his buildable envelope in this instance just that area right there. So I think that's all I have. With that, Mina, I'll turn it over to you.
Is your microphone on? Is that green right there? If it's not, if you would.
Now it's working.
Okay, if you could state your name and address again so we can pick it up.
My name is Mina. I live in 5629 Deer Valley Trail, Antioch, Tennessee. And today I'm proposing if we can use the code's setbacks instead of the contextual setbacks, because the contextual setbacks will affect the lot to have a very small building envelope. And just because of the shape of the lot.
Okay, this existing house, which is can you pull up that diagram? Just question, how is that's over the property line, where both these lots owned by the?
Correct. Both lots owned by concrete investment.
You have to speak up.
Yes, the house right now sits on both lots.
Okay.
Yeah, it's a single lot, Mr. Chairman, on the lot. They're going to build a HPR arrangement, but
Right.
it's just a one, I can pull up parcel viewer to show you a little better. Let me do that.
That's the current house.
Yes, sir, that's the current house on the property. And I'll pull up parcel viewer for this address so you can kind of see. So pull that over here. So this is the lot before you today is the orange colored lot. As you see, a lot of those lots adjoining his, at one time in the past, this whole triangle right here was two separate lots. Or one lot that consisted of two underlying lots. So those lot lines have been established. And then the area, to give you an idea of, from an aerial photo perspective, this is what's currently on the lot.
So Joey, these were two separate lots or?
Yes, sir. On the original plat, there were two separate lots. Back when the original home, the home that's currently on there, the property owner had them both in a single.
Why are unbuilt structures showing up on the parcel viewer? I've never seen that.
Yeah, the mapping division, when they get the HPR condo docs from the Register of Deeds, they map those exhibits
Do they?
in Exhibit A. Yes,
That they get from the site plans filed
from
here?
the site plan in
Okay,
the
I've never
document.
seen that.
Now, we know from, at least from our standpoint, these aren't necessarily where the buildings will be sitting, but, because we have to do the zoning review and those rectangles shift in the real world, but.
So did, so it was one lot, but then I guess the applicant bought it and split the lots? Just
No.
so we understand.
Yeah, this particular, we can find that. I don't,
The applicant owned both lots, so the encroachment didn't matter of the current residents.
yeah. Because they're under separate HPR regimes, but this was originally one big lot that was deeper.
Any questions for the applicant?
Oop, that's gonna-
And there's no opposition, correct?
No, sir.
Okay, we'll close the public hearing and discuss. To me, there's definitely a hardship here in the pie-shaped lot. I don't, could we ask, that's not much of a building space if you don't we don't grant a variance. Could it be less of a variance? Yeah, but it seems,
Does it have to be two?
yeah, it's too, well, it's an HPR, so it'd be But it's two structures, yeah.
No, I know, but I'm saying like, I don't know, you're granting a variance to build, right? I'm saying, would it be less of a request if it was one structure instead of two?
It would be, or they could have two structures and ask for, less of a variance, but, I mean, it seems reasonable in terms of the alignment with the rest of the area but yeah, I mean, and I think.
I mean, I come from my perspective, they buy the lots, they know the restrictions. There's onus, and we've done this before, like there's onus on people that purchase properties to understand the restrictions, and not like it's a binary thing, one or the other, but, anybody that does standard due diligence knows that you can get two, probably three, but four is a stretch. And granted, yeah, this is a odd-shaped lot. There's certainly a hardship, but this is just filed in a category of like, okay, there's a hardship, I'm going for it, kind of a situation. Then, okay, there's a hardship, let me see what I can make work, kind of situation.
Yeah, that's what, I agree with you. I do think it's an odd-shaped lot, but some of it, is it like self-imposed by like what you're trying to get out of the lot? Like, yes, it's an odd-shaped lot. Yes, you're entitled to a variance, but what's the balance? What's the limit? Are we narrowly tailoring our variance, or are we just giving it to you because, to his point, oh, it's a pie-shaped lot, give me this variance. I didn't narrowly tailor my requests, so. No, it's not much, I understand, but I also know Mr. Pepper's perspective, and I agree with that too. The way he's looking at it is, it's an odd-shaped lot, and he can build an HPR, so that's what he's requesting, and that's probably how you look at it, right?
I think it kind of is. I mean, it's case by case, really. I mean, you could put one building here and be asking for less of a variance, that's for sure. I think sometimes.
I think they did it piecemeal though, like to Mr. Ransom's point, but go ahead, I'm sorry, I didn't mean to.
Piecemeal you mean?
They did one application HPR and then they did the other one.
I have concern about variance because I think there was an email, they are concerning because this is being a curve. So the person wrote was concerning site distance because by allowing this house to be closer to the street, how's the visibility coming through the corner? And also I understand, yes, it's an odd shape. And yes, this allow duplex, but does it have to be detached duplex? It can be attached duplex and little setback. So I agree it's not really site specifically catered. Just because they won't build to detached unit does not mean that constitutes variance or hardship to me. So I'm having a little hard time just because it's a pie shape and just because they can build a detached duplex, and should we allow it? Is this a hardship enough? So.
Yeah, they're going from a 48.9 contextual to 20 feet.
It's a big jump.
So, I mean, I would be fine if somebody wanted to propose. I mean, I think my position is they're entitled to some variance here. Where's that line? But I would be fine with, if board members think that that's too much, then, and we only, we make them have a 30-foot setback or whatever. I don't know what the.
Yeah, they're on the, the inside corner of the turn. I know we're not NDOT over here in sight distances, but.
Right.
If it was on the outside corner, it's a little bit different, but.
I do think if you push it back far enough, though, it's probably going to eliminate their ability to do something they do have a right to do, which is build an HPR. I could be wrong about that. I'm not an architect, but.
But you can have an HPR in one building, right? Yeah. So you could imagine, Ross, that one of these gets bigger and it turns 90 degrees, so you have a longer flat one pushed back.
Yeah, that's very true.
Now, will you get to the 48? No, but will it be pushed back and be a little bit more narrowly tailored? Probably. So, and then I don't see anything in here. I mean, the site distance was a concern of mine. I'm over here on Google Map trying to figure it out, but that's not really necessarily the way to do it. But that is a pretty close to the road. And these are gonna be tall structures too on top of it.
I mean,
so.
the applicant has heard our concerns, and we've done this before. Remember, we did this for one in like Madison a couple months ago. We can ask him to come back with, because instead of us giving him something that he can't work with, it's probably best for him to come back with something that sort of addresses our concerns, but still gives him a variance. That's just my thought.
Does anybody have any thoughts about what, if 20 feet is not acceptable, what is in the range of acceptability that might help the applicant?
I think the best thing is for us to, instead for us to determine, our applicant heard our concern, and maybe it's best for us to defy it, and then ask applicant to come back with a better adjustment.
Okay. Is that a motion?
Yes. Let me ask a question to the applicant. How long will it take for you to modify the plan? 1 meeting, 2 weeks, or 1 month?
2 weeks could be enough.
Then I make a motion to defer.
He had one other
Oh,
question.
sure.
Just to bring up, the 20 feet is a codes, 20 feet is a codes setback, and it's not, so if this was, let's say just, example, if this was a new subdivision, and we would put these houses, codes would allow for 20 feet. So 20 feet is okay with the textbook, with the code book. Just the 48 is just because of average 4 houses on the right and 4 houses on the left.
If it was a new subdivision, all the other houses would also have 20 feet as well.
Correct. The contextual setback is the setback. I mean,
Yes.
It's a setback.
Yes, yes, just
We
wanted to.
get that. We understand what you're saying.
Thank you.
So 2 weeks is enough?
Sure.
Okay, so that's February 19th, I believe. Okay. So is that your motion?
Sure, I make a motion to defer 1 meeting.
All right, I'll second that. There's a motion and a second. Any further discussion? All in favor? Okay, that passes.
Okay, this board will be adjourned. Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.